What are some things that material? Good morning. If you're just joining us, we're getting set up and you're telling me in the chat, what are some examples of material facts? Not the definitions, but what are some examples? So you guys are starting to roll in here. Let's see what we got. Oh, that's a good one. It's a good one. Yep, yep, yep. I was looking for that. Yep. I'll start reading some of these to you guys in just a minute. I know you can't see. See, grab a few more of you out of the waiting room. So let's see what we're getting. Roof leak. I've seen the roof a couple times. Structural issues. There's a cracked foundation. There's just flat out structural issues. Shake your head yes or no. Am I qualified to say structural issues? You need to get this fixed right away. No. What am I qualified to say? This structure concerns me. I think you should talk to a structural engineer. Everybody with me? Stay in your lane. Another roof, flooring. I've seen subflooring gone bad a couple times. Old windows, cracked windows. Yeah. Let's see what else we got. What other good things we had in here? Legal issues. That's a great one. If you know of any. Let's see. Basement flood, zoning. Any kind of a proposed zoning changes, zoning amendment. I mean, think about it, you guys. We live in areas, presumably in areas of growth. So we're seeing residential turned into commercial. Would that be important to you if you were going to buy the house next door, knowing that eventually it could be rezoned into commercial? Could that be important to you? Absolutely. Depending on who you're going to live next to, right? Who are your neighbors? So yeah, zoning issues. I'm seeing a couple lead-based paints. Mouth the year to me. Lead-based paint. Anything built prior to 1978. That's a good year. Covenants. Yes. That's a good one. Meth. Yep, a meth lab in the home. Carpenter bees. You guys got this. Stucco, specifically synthetic stucco. Real stucco is okay. Synthetic stucco is fake, and that's the stuff that causes the problems. That's what is material, is the synthetic. Ooh, road widening project. Yeah. Would that be important? Do you have anybody in the Kernersville area? Where are my K Vegas people? Anybody? Few of you, not many. Okay. Are we familiar with Kernersville? Have we driven through Kernersville lately? Y'all, they're building a big old belt loop. You know what? I moved to the Triad in 2000. I've been on the scene for 25 years now. And they were talking about that belt loop when I got here. When did they actually start construction? We're just now starting to see phases getting finished, right? We're just now starting to see this come to fruition. But 25 years ago, even though we didn't see equipment, it was important that if you bought in that area, you knew you could be affected. You could lose your property if you were in that Beltline loop. There's lots of eminent domain going on. So, yes, road widening projects. When it comes to material facts, I think if you can kind of put yourself in the buyer's shoes, would you want to know this if you were buying this home? Would you want to know this if you were living here? And I think that goes a long way in deciding what is material and what is not. So, I'm a big fan, y'all. Y'all want to know my philosophy on this? When in doubt, disclose. I'd rather have a client look at me and say, Julie, I don't care about that, than find out after the fact that they do. I will say if it's high ticket items, if there's lots of price tags on it, like structural work, roof work, flooding, that kind of thing, yeah, I would say that's definitely material. But yeah, a good rule of thumb is that common knowledge. If you were buying this house, not even buying it, if you were just going to live here, if you were going to be a tenant and live here, would you want to know? Material facts is so, so very big. I hope we picked up on that last week. Not just for your exam. You're not going to have a boatload of questions about material facts on your test. You'll have a few, absolutely. But the big thing about understanding material facts is when you get out in the real world. And the best reason why I can give you is that chart that I showed you. Almost 50% of disciplinary actions the last few years have been because we've mishandled material facts. Any questions on material facts before we take off? Good morning. Also, last week we got started in unit 4, and we got to this point, but just a quick recap. We talked about some laws that affects how I solicit consumers. How am I going to get my word out there? And really, y'all think outside of the box, be creative. There's just a couple rules for advertising that we have to follow. You can't pick up the phone and start cold calling without getting your hands on the do not call registry. If somebody wants to unsubscribe from your email, whether they click on the teeny tiny unsubscribe button or they actually reply to your email and say, please remove me from your list, we're going to honor that request. National Association of Realtors and tortious interference says I can't solicit somebody else's active client. So once they tell me they're in an agency relationship, hands off, total respect for that relationship. I'm not going to interfere. And then I think another, or probably the biggest thing that we talked about last week in Unit 4 so far is that Sherman's Antitrust Act on price fixing. And it's so important, you guys, that words matter. So when you're at that listing appointment and the seller looks at you and says, how much are you going to charge me to list my home? I need you to stop and think for a second before you open your mouth. Because it's so easy to say, well, everybody around here charges the same thing. I'm sorry, you just engaged in price fixing, and that's an illegal act. So your answer, make sure you always get my firm charges X amount. My firm's policy is that we collect X amount. This is what my firm tells me to do. You've got to get those words in there to let the consumer know that we're not colluding. We're not all coming together and setting that commission. We don't set referral fees. We don't set commissions or bonuses. Good morning. It's all up to the firm's policy. So words matter, you guys. Any questions on anything before we get going? Let's get going. Picking up where we left off in Unit 4, and we're going to take off today with Federal Fair Housing. Again, it's kind of like material facts. You're going to get a test question or two on Federal Fair Housing. Absolutely. Federal fair housing is more important than we understand in the real world. So at the end of this section, once we go through and understand what we need to understand about federal fair housing, at the end of this section, we're going to put the broker role on it, specifically what we need to know. But until we get there, we got to talk about a few things. Specifically, we're going to talk about something called the Civil Rights Act of 1866 and how that eventually evolved and became what we know today as federal fair housing. So we're going to talk about that evolution. We're going to talk about how we started in 1866 and how we came to be where we are today. And of course, a conversation with fair housing, we have to define the protected classes. So we're going to define specifically who those protected classes are and what that means to be a protected class. We're going to talk about federal fair housing is the main part of this, give a couple examples. And we also have, it's not down here, but we also have North Carolina fair housing. So we got a federal level and a state level. So we'll talk about the difference in the two, how they differ. And then we're going to talk about some landlord-tenant situations specifically for those with handicap, disability, and the modifications and accommodations that a landlord needs to allow. So, history lesson. Let's go way back in time. Civil Rights Act of 1866 came to be. My history buffs can tell you that this was about the time we were wrapping up the Civil War. Things in this country were changing. Slavery was abolished. Things were happening. And so laws and acts and rules are just natural. And the Civil Rights Act of 1866 came in and said, all citizens of the U.S. shall have the same right in every state as enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. So Civil Rights Act of 1866 addressed all citizens, specific one protected class that we'll see in just a second. The big picture of fair housing, guys, today, even today, the big picture of fair housing says everybody should have the right to live wherever they want, as long as it's in their financial means. I'm going to say that again. The big picture, keep this in mind. The big picture of fair housing says everybody should have the right to live wherever they want, as long as it's within their financial means. So the Civil Rights Act of 1866 addressed all citizens, but specifically the protected class that was introduced to us in 1866 was race. I will define the protected classes in just a second. So we will talk about what race is. Please bear with me. One thing that's unique to the Civil Rights Act of 1866 is that it applies to residential and commercial. There are no exceptions to this rule. Still applies today. Residential and commercial, no exceptions. So you cannot be denied housing under this act. You cannot be denied commercial space, business land, commercial, industrial, things like that. Please make a note for me, you guys. There is some conflict with this rule. If you were to go to Google, for example, or whatever your favorite source is, and type in the Civil Rights Act of 1866, I can almost promise you that half of the material you find will say that it protects race. The other half of the material find will say race and color. This is what I know, and please listen. Your exam is based off of the syllabus. The syllabus says race. So can we all agree, for the purpose of your exams, the Civil Rights Act of 1866 protected against race? And as you find other literature out there, I'm always going to refer back to the syllabus, because the commission says if it's in the syllabus, it's a testing point. So this was 1866, long time ago. You don't need to know this, but again, just to help with our history lesson, throughout the years, there have been obviously some court cases that have challenged not only the Civil Rights Act of 1866, but just fair housing in general. So a couple of the cases you probably heard of over the years, again, you don't need to know this, but in time, let's see, we said Civil Rights Act of 1866. So let's fast forward 102 years to where we merged, we combined, and the Federal Fair Housing Act of 1968 was created. So Civil Rights Act of 1866 eventually, over a lot of time, evolved to what we know today as federal fair housing. Other protected classes have been adopted since 1968, so we'll address those in just a second. Federal fair housing is administered by HUD. HUD stands for the Housing and Urban Development. We're going to talk about how HUD enforces fair housing, what that could look like. All that's coming. And before we get too much further into the protected classes, understand no matter who you are, broker, non-broker, it is still a violation. Discriminatory advertising is never allowed. We're going to see some exceptions to fair housing, and there might be some exceptions to when people may or may not be able to discriminate, as wild as that sounds. So we're going to look at some exceptions. But nobody, despite the exceptions, despite the what ifs, nobody can advertise their discrimination in their advertising. So if they are an exception, if they do want to exempt, they still can't advertise that discrimination. So making sure, as you guys are, most of you are going to be promoting property. You're going to be promoting property. But if you start putting people in your advertising, shake it up. Show representation of the people that we are, for example. So here we go. 1968. So in 1866, we were cruising along with race. Federal Fair Housing Act came to be in 1968. And in 1968, in addition to race, we also picked up color, religion, and national origin. Again, I will define all of these in just 1 second. As society evolves, as we evolve, fair housing has to be expected to evolve with us. So again, we went 102 years where race was the only protected class. And then in 68, we adopted color, we adopted religion, and we adopted national origin. Fast forward one more time to 1974, and sex was picked up as a protected class. Again, my history buffs, women's lib. I could get a credit card all of a sudden. I could vote. Things were happening. And so we decided at some point around 74 that sex should be a protected class. You should not be denied housing because of your gender. Make a note for me, you guys, as we just mentioned, fair housing, as we evolve, fair housing is going to continue to evolve with us. In February of 2021, under the category of sex, now also protected is sexual orientation and gender identity. So as of 2021, sexual orientation and gender identity are now protected classes. That's the last update that I know of. Again, as we continue to evolve, we can expect to see fair housing keep up with us. So that's 74. Fast forward with me one more time to 1988. And we picked up handicap, disability conditions, and familia status. We'll define that word in just a second. So here they are, your 7 protected classes and the orders that they came to be. In addition to knowing what the protected classes are, which I'm getting to next, I do think you guys need to know the years that they came to be. For example, I wouldn't put it past them on your test to say, for example, the year is 1972 and a woman was denied an apartment lease because of her sex. In 1972, could you be denied an apartment lease? Could you be denied a lease because of your sex? Yes, because in 1972, that sex wasn't a protected class. So knowing the years are important because it helps us know to be when they are protected, when they started enforcing that. So if these are the years, let's define the protected class. And the best way I know to remember these 7 is to think of fresh corn. The E and the O in fresh corn are not protected classes. They're just they're fillers. There to help me fill in the gaps so we can define the protected classes. So what do all these mean? Well, first up, I got familia status. Familia status is about the children. Familia status is about minors. Anybody under the age of 18 is protected, and that does include women with child. You cannot be denied housing because you have kids. I think this comes up more in the for lease world than it does the for sale world. We'll address the for sale world. But what this is protecting, I mean, we know kids, they destroy stuff, right? They tear stuff up, they rip stuff up. You give them a purple marker and they're going to go nuts all over your pretty walls. And landlords very well may think to themselves, I don't want kids in here destroying this house. I don't want them and their purple marker writing all over my walls. So I'm not going to allow children, families with children, to rent my apartment, rent my home. And the answer to that is, I'm sorry, familia status is a protected class. You cannot be denied housing because of children. And this does include women with child. We're going to talk a little bit more about familia status, how it relates to the sale situation as well, in just a minute. The first R is race. Race is defined as the group of people that an individual was born into or they have affiliated with their whole lives. Race is defined as the group of people that an individual was born into or they have affiliated with their whole lives. The E in fresh is just a filler, equal opportunity for all. The S is sex. This is our gender, gender assigned at birth. And again, as of 21, also protected under sex now, sexual orientation and gender identity. So what gender do we identify today is a protected class. The H is our handicap disability status. Please make a note, handicap or disability, those words that are used interchangeably. This is referring to any physical or mental impairment that limits one or more of life's major activities. So disability handicap condition is referring to physical or mental impairment that limits one or more of life's major activities. The C in corn is color. We're referring to the actual color of an individual's skin, the actual color of a person's skin. The O again is just a filler so I can spell the words. Equal opportunity for all. The big picture of fair housing. The R in corn is religion. Religion is referring to one's spiritual beliefs. Religion refers to one's spiritual beliefs. And then the N in corn is national origin. This is the country where one is born or where their direct ancestors came from. National origin referring to where one hails from, where one's born, or where their direct ancestry hails from. And here it is, you guys. According to Federal Fair Housing, these are the protected class. Now that do I have any questions on the definitions? So now that we've defined the protected classes, let's talk about what this means. I'm going to start by telling you what federal fair housing does not say. Federal fair housing does not say, these are the protected classes. Don't you say anything bad about them. That's not what this is about. Federal fair housing says, here are the protected classes. Don't say anything at all. They're protected. So we're not going to talk about, we're not going to discuss the people under the protected classes. This kind of takes us back to dual agency, where you said you could talk about the property all day long. But flags go up when we start talking about the people. Now, we're also tasked with educating the public. The public may not know or may not understand the protected classes or what it means to be a protected classes. So I am going to talk about them to help educate the public. But we're going to educate the public federal fair housing's way, not your own personal beliefs, your own personal opinions. Because I'm telling you right now, federal fair housing does not care at all about your own personal beliefs, your own personal opinions. And those personal beliefs, those personal opinions have no place in a real estate transaction. So stick to the facts, you guys. Your opinions don't matter here. Stick to the facts. These are the protected classes. And again, we're going to expand on these a little bit, give some examples. Another big picture of fair housing, and I think this screen really sums it up for us nicely. Another big picture that fair housing says is what we do for one, we do for all. We're going to treat everybody the same because everybody you work with is going to fall under one of or more of these categories. So what you do for one, you do for all, which is why I'm such a big fan of checklists and systems where you can put it in the file at the end of the transaction and say, yes, I pulled these reports. I did this marketing. This is what I did for this customer or client. And guess what? It's going to be the same for the next, the same for the next, the same for the next. What we do for one, we do for all. And don't forget, under handicap disability, when we're talking about things that are not material facts in North Carolina, if anybody ever lived in the home that had AIDS or HIV, remember our answer is always federal fair housing prohibits me from answering that. Has anybody ever lived here that had AIDS? I'm just curious. I don't want to know. I'm just curious. My answer is federal fair housing prohibits me from saying that. And that's because those with AIDS or HIV are protected under handicap disability. And it's not that we're not saying anything bad. We're not saying anything at all. Federal fair housing prohibits me from answering that. Questions so far? Let's kind of some expanded definitions here. Familial status, like we said, is about the children. It has nothing to do with marital status. You may want to make a note. It has nothing to do with marital status. It has everything to do with the children. So those under the age of 18 and women with child. And the thing to be aware, I mean, we said you may find a landlord. By the way, you don't have to be a broker. You still have to or should follow federal fair housing. There are consequences out there as well. But the landlord may not think that they not want to rent to kids, to families with kids, because like we just said, kids, they're little monsters. They destroy stuff. They tear stuff up. That's what they do best. So the landlord may think, well, I don't want these little monsters living in here. You cannot be denied housing because you come with children. I do think where this comes up most often in the sales side is you may have a buyer with a family look at you and say, are there any kids in the neighborhood? We want a neighborhood with kids, so little Johnny has somebody to play with. I don't know about the kids that live in the neighborhood. I don't know if the kids in the neighborhood will want to play with little Johnny. I don't know, nor do I need to find out. I need to help that buyer, help educate that buyer. We're not going to talk about the kids in the neighborhood, whether we know or not, but instead, let's talk about the amenities. Let's talk about things nearby. What do kids like? Parks, playgrounds, soccer field, right? Rec centers, schools, right? What nearby is for the children? Remember, we're putting everything in Google, all addresses in Google anyway, to help learn about the property, the area. So we'll be able to easily see, is there a park nearby? Is there a rec center, or a ball field, or whatever it is specifically they're looking for? I'm not avoiding or diverting from the subject. I'm just redrawing, refocusing the attention. I'm not going to talk about little Johnny, but what is important to little Johnny? Is it the playground? Is it the school system? That may not be important to little Johnny, but it might be important to mom and dad. Maybe they want in a specific school system, a school location for little Johnny. Again, you guys, when somebody says something about the children, when somebody says anything about the protected classes, do not go, la, 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 I can't talk about that. No, we're going to help educate the public. I appreciate what you're saying. I appreciate what you're asking. The familial status is a protected class. We can't talk about the children of the neighborhood. No, we can't talk about the children of the neighborhood, but instead, let's talk about what's important to the children. And you know, the other thing I have to say about this, when your buyers are under contract, encourage them to drive by the home a couple times a day. So drive by first thing in the morning. Where does the sun rise on this home? Drive by in the afternoon. They're more than likely to see a school bus if there's kids in the neighborhood. You know, is this a party neighborhood? I don't know. Drive by at 8 o'clock on a Friday night and see if anything's going on. So we're going to help them learn about the property, and some of that learning gets off of the internet. I know when we bought this house, y'all, I set my alarm for like 6 o'clock in the morning one morning so I could drive by here to see what it looked like first thing in the morning. My husband said I was crazy. He did not join me, but I wanted to see what did it look like in the morning. I wanted to see what it looked like at night. I wanted to see. And I think we should encourage our buyers to do the same thing. And that will help them determine what they might be looking for. I'm going to help them locate the amenities, help them locate the things for little Johnny. Questions on familia status? Another expanded definition, let's talk a little bit more about handicap disability status, specifically as it relates to the landlord tenant situation. Remember, you guys, I'm talking about federal fair housing. Federal fair housing is only for residential transactions. This has nothing to do with commercial. It's all about residential. So you have somebody with a handicap disability that wants to rent an apartment or rent a home. The one thing the landlord cannot do for accommodations is say no. So if somebody rents your home and they need to build a ramp up to the porch, or if they need to come in and lower the kitchen cabinets, maybe they need to put grab bars in the shower. These are examples of accommodations. And the landlord has to allow the accommodations. The landlord can't not say, don't you put grab bars in my shower. They have to allow, they cannot say no. Now, here's the deal. Oftentimes, those with the handicap disability will be responsible for paying for the accommodation. You may even see that in the lease. There are funds out there to assist with building ramps, for example. And the landlord could request in the lease, in writing, at the end of the tenancy, the tenant put things back to its original condition. So at the end of the tenancy, tear down the ramp. At the end of the tenancy, take down those grab bars, and any damage to the property done by removing those accommodations can be on the tenant Again, funding is often available. So the landlord can't say, no, I don't want you to do that. That'll mess up my home. They can't say no. There's a lot to think about before you let somebody rent your home. They can't be denied a lease application solely on because they have a handicap disability status. We're going to talk about, when we get into Unit 13, we're going to talk about those tenant applications, what I can and cannot look for. I can't say, nah, this applicant has a handicap disability and they want to build a ramp. On to the next. No, they're a protected class. Compare accommodations to modifications. This is a hard alteration. Landlords are not going to be responsible for major modifications. They're not going to be responsible for coming in and doing major changes. What they have to allow, though, is accommodations.
I have a question, please.
Yes. Yes. Hey, Raj.
So if you know how you can't advertise against these different protected classes, can you have advertising that says this apartment is handicap accessible? And if so, is it within the rules because of the added expenses to say add ramps or those grab bars or different accommodations in the unit? Could you charge extra for that?
No, the landlord couldn't, but the tenant, I mean, you could up the rent, but if you're gonna up the rent for one, then you'd have to up the rent for all new applicants. You just can't up the rent just for this one because of whatever kind of accommodations they need. As far as the advertising, handicapped accessible, oh, please be careful with that because we're talking about the protected class. I know sometimes you know, you might see that, and I feel like that's just very, I know it sounds good because we're inviting those with a handicap disability status. Um, but I would go to your BIC first because we're like on a very gray area right here. Because we're putting it in our advertisements. We're putting it in our advertisements, and that's the concern there.
Thank you.
We are talking about federal fair housing right now. At some point, we're also going to talk about something called the American with Disabilities Act. Please go ahead and write that down for me. American ADA, American with Disabilities Act, and we'll talk more about it. American with Disabilities Act addresses the public spaces. So fair housing is about the dwelling where we live. ADA is about the public spaces. So if it's an apartment complex, for example, that has, a pool and a clubhouse and a parking lot and a playground and a dog park, those amenities are public places. And so some landlords have to abide by both Fair Housing and American with Disabilities Act. Those landlords that deal with public accommodations, public spaces under ADA, under the American with Disability Act, some examples of accommodations, maybe we have some additional parking spaces. We could put braille. If we have elevators, we could put braille. And the elevators, or maybe those push to open, to accommodate those. Again, American with Disability Act is about the public spaces, and its big picture says that everybody should have the same and equal access to all public places. So if we have a clubhouse that's on 5 stairs, then the landlord would be responsible, or the owner would be responsible for putting a ramp or whatever it is we need to do to get those up into the clubhouse. Same thing with the pool. I know a lot of pools we're starting to see, more and more I'm seeing it. The chairs, that the one with maybe in a wheelchair can sit in a little chair and they can be dropped or let down into the pool, so they too can enjoy the amenities of the pool. So federal fair housing is about the housing, it's about the residents, it's about the dwelling. ADA picks up for the public spaces, the public accommodations, where federal fair housing leaves off. And yeah, some have to abide by both. So again, different modifications, in the public spaces, let's say there's a building, I don't know, it's a public space and it's a building and it was built in like the 50s and this thing is 2 stories tall. Well, back in the 50s, they probably didn't have to, or they didn't have a need to put an elevator in. So, they're not going to make you come in today and put an elevator in. They're not going to make you do those hard modifications. However, if you apply for a permit to do major renovations, or if you're going to do demolition and rebuild today, if you want the public to go to the second floor, then today you'll have to rebuild with an elevator. Does that make sense? They're not going to make you do it, but if you rebuild or major renovations, they're going to make you get up to code. So things to keep in mind. Landlord deals with, if it's a single family home, that's all covered under federal fair housing. But when we get into these apartment complexes, when we get into areas with ADA, then we're looking at federal fair housing and ADA. Again, more on that later. A couple of things I did not mention, things that are not protected, not part of fair housing. Marital status, I think we mentioned that, single, divorced. It's complicated. That's not a protected class. Occupation, what you do for a living, is not a protected class. In age, once they turn 18. Once you turn 18, you no longer have that protection. You no longer, have that familial status and that protection of age. Questions? So as mentioned, there are a couple exceptions to federal fair housing. One exception from federal fair housing is basically the for sale by owner. Sale of a single family home when you have less than 3 homes at one time and you're not selling more than every 1 or 2 years. This is a true for sale by owner. If you're an investor that buys homes, flips them, and sell them, and you do this several times a year, then you're not exempt. So it's only those that own less than 3 homes at a time and do not sell more than every 1 or 2 years falls under this category. So technically speaking, what we're saying here is that the for sale by owner is exempt. And the for sale by owner could choose to discriminate against who they let into their home. Now, I know this did not set right with us. This bumped on our moral compass, and I get it. I have a solution. I have an answer for you in just a minute. Please bear with me. And remember, even the FSBO cannot advertise their discrimination. So they can't put an ad out there about who need or need not apply. But they could discriminate. They could choose. I got a solution in just a second. Bear with me. Another exemption to federal fair housing is a 1 to 4 unit owner occupied dwelling. So if you own a quadplex, you have a building with 4 units, and you are the owner and you're going to live in one of those units and you want to rent out the other 3, you can choose. You can discriminate against who does or does not live in the other 3 units. Owner occupied. Again, you can never advertise your discrimination. So if I own the duplex and I was going to live in the unit on the left and I wanted to rent out the unit on the right, I may say, for example, I don't want any men to live next door. I want a female to live next door. And I have that right, assuming I'm not licensed. But I cannot advertise my discrimination. I cannot say men need not apply or female applicants only. Once you're licensed, y'all, it's a game changer. More on that. Another exemption to fair housing are properties, residents owned by religious organizations or private clubs for the benefit of their members. So for example, the church might have a parsonage. The parsonage is owned by the church. They can say that only the members can use the parsonage. What if the Elks Lodge or the Elks Club has a lodge up in the mountains? Because the Elks Club is a private club, they could choose only to allow their members to stay in to use that lodge. Not-for-profit organizations, we're going to talk about a little bit about low-income housing, public assistance, again, not protected classes. It's addressed under the big picture of fair housing. Other exemptions to federal fair housing have to do with age and age only. So another exemption is housing for older persons. If the community, if the development, if it was created for the purpose of allowing older persons to live here, then they are exempt from familia status only. The other 6 protected classes still apply. You can have a housing for older persons if everybody that lives there is 62 or older, 100% of the residents are 62 or older. They would be exempt from that familia status. And if the development was made for a community of 55 or more, as long as 80% of our residents are over 55, then we can exempt from familia status only. There's still can't discriminate against race, sex, etc. So the exemptions for older housings for older people only exempt the familia status. So what we're saying here, the grandkids can visit. They can pack up their little backpacks and they can go stay with grandma and grandpa over the weekend. The grandkids can't live there because these were designed specifically for older persons. And like we said, again, bear with me, the for sale by owner or the for lease by owner, the FSBO or the for lease by owner has the right to discriminate as long as they've not brought a broker into the transaction. Anytime that a real estate agent in North Carolina gets involved in the transaction, exemptions, discrimination goes out the window. So the FSBO, they didn't hire a broker, they chose to go for sale by owner. But if the buyer comes with a broker, now a broker is involved in the transaction and discrimination can no longer happen. Once you get a broker involved, all discrimination goes out the window. Nobody can advertise their discrimination. And I get asked all the time, you guys spend a lot of time on Craigslist. Well, I saw this on Craigslist. Okay, on Craigslist, there's no rules, there's no filters. Just because you see it on Craigslist doesn't mean that it's allowed under federal fair housing, for example. So, as I've mentioned, once you're licensed, you guys, discrimination totally goes out the window once a broker gets involved in the transaction, whether you hired me or not. Once a broker gets involved in the transaction, then discrimination goes out the window. Questions or comments so far? Yeah, I don't know. I get asked about it all the time, so I guess it is. I don't know. I don't think I've looked at it once. And guys, I hate to say it, it's 2025, but we still deal with this. You very well may, you're at a listing appointment And at some point during the listing appointment, the seller may look at you and say, I don't want to sell my home to fill in the blank of a protected class. This is my opportunity to help educate the consumer. I have tools, I have pamphlets and brochures. We'll look at some of your resources in just a second. But maybe I can provide them the brochure and say, seller, once you bring a broker on, we're not going to discriminate. The individual's name shouldn't matter. That should not be the reason why you're not selling your home to this individual. Sellers, as far as I'm concerned, should only see one color. And that color is green. Can they afford to buy my home? Do they have the means? Can they get the loan? Can they prove they have the cash? That's as far as it should go. So the seller says, yeah, I hear what you're saying, and I know what you have to say. But I'm telling you, I'm not going to sell my home. If an offer comes in with this member of the protected class, I'm going to say no. I'm going to reject the offer. Go to your BIC at that point. Have a conversation with your BIC. Maybe your BIC can talk to them. Bottom line, guys, if that seller is not going to budge, it is recommended that we not take that listing. In some cases, it's best that we walk away. And if that seller's not going to budge, you and your BIC have both tried to explain, and that seller's adamant, I will not accept this offer. You have a decision to make. Because remember, once you're in, it's old car all the way. And also remember, old car says we follow our clients' lawful instructions, and I cannot follow their instructions to discriminate. I don't know. I probably wouldn't want to work with that person anyway. So we always have decisions. We always have things to consider before we enter into those agency agreements. Questions so far? Yeah. Did I hear someone? Amber, hey.
Yes. Just a question about like if you're selling a house, and this is a personal experience. If a person is selling a house and oops, didn't want that one. And let's say they had a crazy ex, whether a male or female, it doesn't matter. That was involved in a really abusive relationship. Ask the listing agent or your agent not to show a home with a certain person just out of fear of damaging stuff, just out of fear of anything like in that perspective.
You're going to have to go to your BIC, because the truth is, when I get a showing notice, I don't know the name of the buyer. All I know is the name of the broker. So this ex could have hired an agent. I want to see this listing just to get themselves in the front door. Obviously, they probably wouldn't be upfront and honest. So unfortunately, the only way to avoid that, and I don't think it would be anything against fair housing, because, public safety, we're not discriminating against a protected class. We're just saying this one person because of the experience. Get with your BIC, because unfortunately, the only way I know to regulate that is before I approve the showing, to actually call the buyer's agent, call the one that scheduled the showing and say, if your buyer is so-and-so, you're not welcome here. But get with your BIC on that. But yeah, we definitely want, if people have concern about their safety, absolutely. I mean, just inviting people into your home is safe, but if you feel somebody's coming in with a different intention, get with your BIC. And maybe, Amber, we allow the showing, but we just make sure that the listing firm has a representative there as well. So we make sure we're protecting our sellers. Maybe you go to the showing, or your BIC, or somebody else in the firm. So there are ways around that. But I think the big picture, I do not think that would be a violation of fair housing, because it's just that one person. We're not saying no men, we're just saying Bob. So, and we have good reason. So get with your BIC on, how to best proceed with that. Good question. Okay, let's take our first break, and when we come back, we got more on fair housing. So let's take 10. We're back. I was just telling you that, Raj. Let me see. I got some Zoom power over here. Let me see if I can't. Nope, I don't have that kind of power. Raj, why don't you log out, log back in real quick?
I'm having issues with mine too. It's like you're freezing a lot. I don't know if it's on my end or what.
I
But
am. Anybody else on freezing?
I even took a little small video on my phone because it's like really bad where I can't hear everything that you're saying.
Sorry about that. I don't have, so it might be on your end, Lauren. I'm not seeing anybody else head bob. So
looks
unfortunately,
like-
my answer is log out, log back in. It can't hurt.
Okay.
Raj, okay. Technology is great when it works, right, guys? All right. So welcome back. I am taking attendance and I'll get Raj and Lauren back in. And we are continuing on. Nope, it's still doing it. Yeah.
Pardon me, Julie, while we're waiting to get straightened out. I just want to make this pitch. If there's anybody interested in a study partner, I'm available. It's kind of hard to study with people that are not interested in the same thing you are.
I agree. I agree. So, and as always, you guys, I'm welcome to leave the call open. If that's one way you guys want to connect with Ricky, I'm happy to leave the call open. Yep. Yep. See that, Raj? Any way I can connect you guys. So if, I will not share your contact information without your permission. So if I can connect you guys, I'm happy to try to help that way as well. But thank you, Ricky, for sharing that. And in the event I forget, please, please help me remember. But yeah, if we want to coordinate any study groups, that kind of thing, I'm happy to help in any way that I can. I know that's honestly the big challenge of being on Zoom. Is you guys just don't get that opportunity to meet. So whatever I can do. Perfect. Okay. Thank you guys for your patience. The next little section, we just got some words to define. So we're going to talk about some words related to federal fair housing. So block busting, steering, redlining, something called disparate impact. And then we're also going to bring in North Carolina fair housing, and we're going to compare how it relates to federal fair housing, what the differences are, and of course, what you need to know for your exams. And then how is fair housing enforced, penalties, that kind of thing. So before we get into it, let's just kind of back up for a second and just define some words that revolve around fair housing. And the first word I'd like to define is block busting. Also known as, I just lost it. I'll get back to you on that one. But block busting, this is what I want you to write down for me. This is the thing to know. Block busting is about the owners, whether you're talking to the seller or the landlord. Block busting is about the owners. If you are engaging in the activity of blockbusting, you are encouraging somebody to sell or lease their home because of the presence or absence of a protected class. If you're engaging in blockbusting, you're trying to bust up the block. You're trying to encourage somebody to sell or lease because of the presence or absence of a member of the protected class. Blockbusting is about the homeowners for sale or for lease. If I'm encouraging somebody to sell their home, it's because upsizing or downsizing or their financial situation is not because of the block, the protected classes within the block. Flip that coin. If blockbusting is about the owners, then steering is about the buyers and tenants. What steering says is that I cannot direct potential buyers or tenants into or away from a neighborhood because of the presence or absence of a member of the protected class. Steering. I cannot direct potential buyers or tenants into or away from a certain neighborhood because of the presence or the absence of a protected class. Blockbusting is about the owners. Steering is about buyers and tenants. I can't steer or direct. If they want to live here, it's because it's within their financial means. They like the neighborhood. It's close to work. They like the school district, whatever. Again, the big picture fair housing says that everybody should have the right to live wherever they want, as long as it's within their financial means. Another fair housing term is called redlining. Redlining is for the lenders. Make a note, redlining is a lender term. Once upon a time ago, lenders would put a map of the city up on the wall, and they would take their red marker and they would literally walk up to the map and say, we're not going to originate loans here, here, or here. They actually circled places on the map that says we're not going to originate loans here. That's called redlining, and that is not allowed. If you're denied a loan, it should be because your debt to income ratio doesn't shake out. Maybe it's the specific property. Not all properties will get loan approval. More on that in Unit 6. But you cannot be denied a loan because of the neighborhood, because of the area that you choose to live. That's called redlining. So again, for the most part, if you're being denied a loan, for the most part, it's because your debt to income ratio doesn't shake out. Sometimes the specific property doesn't qualify. What we're saying here is the whole neighborhood or area or subdivision. You cannot be denied because the house is located there. And another fair housing term is something called disparate impact. Disparate impact is some kind of policy, maybe an office policy, a company policy, or some kind of practice that has an unintended effect of discrimination. The policy was put into place. The policy itself is not discriminatory, but the unintended effect does affect one or more members of the protected class. So disparate impact is about policy or a practice that has an unintended effect of discrimination. However, discrimination still happened, so that policy or practice needs to be revised. Tenants have some protection in North Carolina. Landlords cannot sexually harass their tenants. They can't demand sex for payment as rent, security deposit, things like that. They cannot sexually harass their tenants. Tenants have protections. I got a whole unit dedicated to landlord tenants. So we're going to talk about more about them in Unit 13, but as it relates here. And I just want you guys to make a note. It's pretty good piece. You can find it on YouTube. I would not use this as your study time, but it is a very good piece. Just make yourself a note when you have some downtime or after you get your license, maybe one thing at a time. You may want to just go to YouTube and search A Matter of Place. And that's going to show some very haunting realities of discrimination. Questions? We mentioned earlier, federal fair housing comes to us from HUD. So HUD enforces, so if there is an individual that feels that they've been discriminated against, they very well may hire an attorney, they may hire somebody to help them along, or they may just, go to online and say, I've been discriminated against, what do I do? They can go directly to HUD, but HUD will handle the complaints. Once a complaint is filed with HUD, HUD will do a very thorough investigation to determine if discrimination has in fact happened. They're going to talk to all the parties involved. They're going to talk obviously to the complainant, the one that filed the complaint, but they're also going to talk to the one that the complaint was filed against and anybody else that might be involved in that potential discriminatory act. They're going to do a very thorough investigation. Again, the individual may hire a judge, may go to court, may hire an attorney, I should say, in which case they'll probably know to get fair housing try to get fair housing involved. But the individual does have the right to go straight to HUD. The complainant has up to 1 year after the offense to file the complaint. Statute of limitations on this is 1 year. So if you come across buyer or tenant, landlord or seller, or your family or friend, remember, we're all out there helping to educate the public. And if anybody comes to you and says, gosh, I feel like I've been discriminated against, don't try to be the hero. Don't try to fix it. Don't tell them they're right. I don't know. That's not my job. What I'm going to do is say, my goodness, I'm so sorry you feel this way. Might I suggest that we contact the Office of Fair Housing and Equal Opportunity? You go through the proper channels and file your complaint and go through the process. We're helping to educate the public. You don't need to know the specific numbers, but violating fair housing can be a pretty big deal. Your first offense, maybe, I'm going to say maybe, your first violation, maybe the first offense, they just slap you on the wrist, make you take some additional training and say, don't do it again. What I'm saying here is the first violation. You could face penalties, the individual or the entity, if it's an apartment complex, for example, a business. Second violation, fines get a little heftier. Third violation, everybody's in the 6-digit number range. So fines are healthy, fines are hefty. And again, you don't need to know the specific numbers, but what I need you to see from the screen is that this stuff is real. What happens? So again, one of those old laws says eventually we're going to have to make it to the judicial system. If you don't go, then HUD or Fair Housing probably will, because they can file repeat offenses. We want them in the system. So if it happens, maybe it happened with this apartment complex in this state, and then that individual moved to another state and is applying for a different apartment complex, for example. And then we introduced you to something called our E&O insurance. This was our kind of like our medical malpractice, but for realtors, for brokers. Your firm will usually have coverage, but E&O isn't going to help in fair housing complaints, fair housing discriminations. I don't know of something that can get you and your license in trouble faster than violating fair housing, because not only are you dealing with the courts and the Office of Federal Fair Housing, the HUD division, but now you're also going to be dealing with the North Carolina Real Estate Commission as well, and you could be facing disciplinary action. They will get involved. So, federal fair housing, let's bring it down to the state level. We also have a North Carolina fair housing. Y'all want some good news? North Carolina's protected classes are the exact same as federal fair housing's protected classes. So fresh corn will get you for the national level and the state level. Some states have additional protected classes. They have the 7 from federal, but in addition to those 7, some states have more. I think California has like 12 or 13 protected classes, for example. So the good news in North Carolina is that we have the same protected classes. Fresh corn will get you through both. Thank you, Raj. And the thing to know, the difference in fair housing versus North Carolina fair housing. We got federal fair housing and I got North Carolina. And the thing to know are the differences between the two. And so since the protected classes are the same, the differences come down to the exceptions. So remember that first exception that we said with federal fair housing, that the FSBO, the for sale by owner, or the for lease by owner, could discriminate under federal fair housing? Guess what, you guys? If anybody just looked at that and said, are you kidding me? State took care of it. State stepped in and said, no, we're not going to exempt. Just because you're a for sale by owner or for lease by owner doesn't give you a golden ticket to run around and discriminate. So if you're selling or leasing a home, the property is located in the state of North Carolina, the FSBO and the for lease by owner are not exempt. We will compare the two in just a moment. In federal fair housing, we said that if it's owner occupied, 2 or more units that are 2 to 4, I think, units that are owner occupied, the owner can choose who lives in. If it's owner occupied, we may be able to discriminate who lives in the other units. North Carolina says not just owner occupied, but your family members, if your family lives there, and I would say immediate family, let's not get into our great great aunt or anything like that, but I would say immediate family. You know, for example, let's go down to the Raleigh area. We got a lot of college campuses down there, don't we? We got a lot of college campuses in the state. And you might have parents that buy a duplex for their son or daughter to live in while they're attending college. Because the son or daughter lives there, it's not owner occupied, it's the owner's family. And again, I would say immediate family only. I know we can play the what if game here. Because your son or daughter live in one of those duplexes in North Carolina, then we could choose who lives in the other. And then an exception that North Carolina has that federal fair housing does not. So another way that we are different in North Carolina, any of our single sex dormitories are exempt. So think about our college campuses, our military barracks, for example. Those single sex dorms are exempt in North Carolina, not in federal fair housing. North Carolina fair housing, is enforced by the North Carolina Human Relations Commission. So again, the individual, the attorney, maybe you start on the state level, maybe you start in the federal level. I'm going to say a lot of the answers to that question is it depends, which in some cases, you guys, when your family or friend or client or customer, any member of the public looks at you and says, I feel like I've been discriminated against, what should I do? It might be our best bet is to suggest that they go ahead and hire an attorney, because an attorney will help them proceed through the process. I can tell them about state and federal, but I cannot give legal advice. If the complaint is filed with the state, there's a good chance it'll get pushed up to the federal. If it's filed with the federal, it may or may not get pushed down to the state. Again, it just depends. What type of actions or discriminatory practices are we talking about here? Again, the complainant has up to a year to file the complaint. Statute of limitations is a year. So the suggestion is always, if you're going to go after somebody in a court, if you're going to file a complaint, do it sooner rather than later. Because once that statute of limitations is run up, we've lost our right to file the complaint. State housing, in addition to the, state housing, in addition to the process of determining if a violation happened, and if so, what we can do. They may try to get the parties to work together. What can we do? And if we can't obtain voluntary cooperation, then we may have to go to court. So a lot of you may have a question right now. Okay, Julie, I got federal fair housing and I got state fair housing, and I got some conflicting information. And you're right, you do. So general rule of thumb, anytime you have a conflict between two laws, the more restrictive of the two will apply. So whichever one is more strict will apply in this situation. So for example, federal fair housing says the FSBO can discriminate. State fair housing says they cannot. Which one is more strict? Which one has more restrictions? Yeah, state. So state would rule. Good rule of thumb, may or may not be about fair housing. Whenever you have two conflicting rules, the more restrictive of the two will apply. Questions? All right, let's bring this home. So what's all this mean for us? Well, as the broker, we understand, and not just in fair housing, but in all aspects of the real estate transaction. A big part of my job is to educate the public about the transaction. And that would apply if we bump into or come into any discriminatory practices or activities. So educating the public, again, there's so much good material out there. I don't have to recreate the wheel. The wheel's been created. I have pamphlets that I can provide and review. We can have these discussions. So what I think is important for us to know, you guys, we need to be very, 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 very careful. If the broker appears to have discriminated, maybe you didn't mean to, but guess what? You still left somebody feeling in a way that you discriminated against them. And if the complaint comes down on the broker, we don't even need intent. If the broker has the complaint filed about a discriminatory action, I don't know a faster way to get yourself in trouble. What we do for one, we do for all. Are y'all hearing me? What we do for one, we do for all. Let's say I'm doing an open house on Sunday. And I got it. I did good. I got cookies. I got little bottles of water. I got, my table set up with flyers and my lender's information. I am ready to go. The first group comes into my open house. I say, hey, folks, welcome. Thank you so much for coming today. Feel free to have a look around. When you get to the kitchen, help yourself to a cookie and a little bottle of water. And if you don't mind, please sign my open house registry. Let me know if you have any questions. Second group comes into the open house. Hey, guys, cookies, water, and registry, please sign it. Third group, same thing. So far, I'm treating everybody the same, right? Next person comes into my open house. Maybe I'm busy. Maybe I'm on my phone or I'm talking to another buyer in the home. And this other person comes in and I say, hey, and I go back to doing what I'm doing. And then they hear me with everybody that comes in after them. Get a cookie, get a bottle of water, and sign my registry. Without meaning to or not, did I treat those one people differently than I did everybody else? I didn't invite you to get a cookie. I didn't invite you to get a bottle of water, and I did not invite you to sign my registry. You guys with me? Did I leave them feeling in a way that quite possibly I could have discriminated against them? So have these systems, have these checklists in place. They don't need to prove intent. It's just how we made the consumer feel. They also, anybody ever work or works in restaurants? And sometimes in restaurants, they send those secret shoppers in. So you wait on them and you don't know that they're secret shoppers, but all the while they're rating you, right? Sometimes they will do this through state and federal fair housing as well. I didn't work with, but I had a lady in pre-licensing several years ago, and she worked in one of those very large apartment complexes. I think she said they had like 150 units. And the poor thing came in frazzled on the regular, especially the first of the month when rent was due. But when we got to this, she told us, she was reception. She answered the phone and she was the front desk. So she was there as soon as you walked in the door or as soon as you called. And she told us that fair housing called all the time. They sent secret shoppers all the time, either to apply or to ask questions on the phone. She said, we have to be on guard because you never know if it's a secret shopper. And I think that's a great way to make sure that we're treating the public the same. Now, she did share with us that, if there was something that she didn't do right or something that the company didn't do right, fair housing is going to work with them. She said there were several times we did some training, that kind of thing. But after a while, if those offenses or violations keep happening, then we're going to start looking at possibly fines or filing the complaint to one of the two, federal or state level. So never let your guard down. Don't assume that this person isn't, because they do send secret shoppers. So I want to take just a moment. And if we look in Learn Test Pass, oops. I guess I'm only partially logged in. Hang on. Okay. So we look at Learn Test Pass. Here it comes. Okay. And in the Unit 4 material, there is a couple things I really want to point out. And let me say this while we're waiting patiently for my site to load. Let me say this as well. The National Association of Realtors has declared April, the month of April, as Fair Housing Month. So a lot of firms take this opportunity to refresh their brokers on fair housing. This is certainly not a one and done. This is something we need to be reminded of, especially as it evolves, as things are added, protected classes are added. So April is usually a good month to review fair housing. So if we look in the Unit 4 material of Learn Test Pass, 2, 3, there is the Real Estate Commission's Q&A on fair housing. And this is a great article. It goes over the protected classes, it goes over, federal fair housing, state fair housing, etc. This is one of the Real Estate Commission's Q&As that was written for the public, but I do think it helps you guys as well in learning it. So I do suggest you spend a little bit of time with this. And remember, the Real Estate Commission they're the ones that give you your state exam. So the material that we can learn from that they produce, we know that we're speaking their language. We're knowing what they're saying on those state exams. So I encourage you to take a few minutes and peruse this. And this is what I was saying. Once you get out in the real world, you'll have this accessible to you that we can provide to the public. So if you find you're dealing with a consumer that's having a hard time with fair housing, this allows you to put something in their hand. And what they do with it, I don't know, but it makes it more real than me just standing here talking about it to that seller. So we have tools, we have resources. You do not have to recreate the wheel. The wheel has been created. When it comes to discrimination in advertising, many of our MLSs nationwide have implemented a software, and that software flags potential discriminatory words. So as you're typing your remarks, you're putting your listing into MLS and you're typing your remarks, those public remarks, the system will flag a word that, if used to talk about the people, could be seen as a potential violation, discrimination. It's not telling me not to use that word. It's just saying, warning, know the context. For example, my team works with a lot of builders. And shortly after they rolled out this software, I was putting a listing in for one of our builders, and the remarks talked about the white kitchen cabinets. And MLS flagged it for me, said, warning, make sure you're using this word right. Make sure you're using this word white appropriately. Can I use white to talk about the kitchen cabinets? Sure. Can I use white to talk about the people or the neighborhood? Absolutely not. So it's not saying don't use that word. And I find it very helpful because we may not always see the offensive side of it, the discriminatory side of it. So that's help us identify and recognize. And when in doubt, you guys remember your BIC is always responsible for your advertising. So especially you guys as soon to be provisional brokers, your BIC's probably going to review your advertising anyway, but they may spot check you or continue to monitor it depending on their policy. And this is part of what they're looking for, is to make sure that we're not unintentionally putting discriminatory verbiage or even the unintended consequences out there to the public. Questions on fair housing? Okay. That's a wrap for Unit 4. Big deep breath. Unit 5. I don't have too much to say here about Unit 5 because, as we can see from our little document in our Google Drive, I don't have any test questions directly from Unit 5. However, I would not be surprised if you don't see something on your state exam from Unit 5. So there's a few things that we're going to talk about. I also think Unit 5 is a really good introduction to the world of measurement. I'm not teaching you everything that you need to know about measuring a house, Please, you guys, one step at a time, but this gives us an understanding and it might answer some of your questions. So I am going to go through Unit 5, let's say quickly, until we get to the end of Unit 5. The end of Unit 5 is what I think you might see specifically a test question on, because the end of Unit 5, we're going to continue our conversation with area math. We introduced you to area math back in Unit 4, nope, 2, but now we're going to continue that conversation. So measurement unit, scratching surfaces, teaching you just enough to be dangerous. So in this section, we're going to explore some living area above ground. We're going to talk about above ground versus below ground. We're going to discuss how we determine the square footage of a home, of a property. And then again, we're going to get into that area math again, kind of picking up for the rest of that conversation that we started in Unit 2. So if I were a betting woman, I'd say for the majority of you, the burning question you have on your mind right now is, do I have to measure my listings? Do I have to measure my listings before I list it? As the listing agent, I am responsible for reporting the square footage. And we're going to talk about what that means, square footage of a home. I'm responsible for reporting it, but brokers are not required to measure it. You could hire somebody to measure it for you. Now, I get asked all the time, can the seller pay for that? If that's your business model, if that's your firm's policy, then that's what we're going to do. But just keep in mind, you guys, competitive listing appointment, and you're about the only one asking the seller to pay to have their own house measured. For the most part, it is built into our marketing and advertising budgets for the most part. So I'm telling you guys, you got two choices to make. Either you measure it yourself or you hire somebody to measure it for you. And I think a lot of that comes down to time versus money. You guys have decisions to make, but you don't have to decide yet. Please don't put your cart in front of your horse. I will say this. Some of you are sitting right now there going, oh, I'm going to pay somebody, whatever. I'm not measuring myself. And I hear you. Trust me, I hear you. But I will say this, whether you measure or somebody else measures for you, if you list it, you're responsible for it. If you attach your name as the listing agent, you're responsible for it, and it has to be accurate. All these disciplinary actions I've been seeing recently, there was like 5 or 6 months in a row of square footage misrepresentation, of measuring violations. So if it's determined that it was measured wrong, then that could come down on you. So if you're going to measure it, learn how to do it right. If you're going to hire somebody, make sure they know how to do it the real estate commission's way. Remember, that's my governing body. What about buyer's agents? Would a buyer agent, what do you think? Would a buyer agent have to measure a home? You could shake your head, yes or no. You're with a buyer. Yeah, I'd say for the most part, we can rely on the information provided to us in MLS. So for the most part, buyer's agents are not required to measure a home that their buyer is interested in. However, if any flags go up, I have a duty to verify that. And guys, I'm going to be really honest. I lack the ability, that dimension ability. Like I can't walk into a vacant room and say, oh, the couch will fit right there. I lack that dimensional ability. However, if I walk into a room, let's pretend I walk into this room and it's advertised as 250 square feet. If in reality it's 210, nobody can eyeball 10 square feet. Nobody, I don't care how good you are. Nobody can eyeball 10 square feet. So if this room is actually 200 or what I say, 250, and it's advertised as 260, I'm not going to be able to determine that. However, if this room is advertised as 450 square feet and it's actually 250, I should be able to walk in the room enough to be able to say, golly, this doesn't look like 450 square feet. So although I don't know precisely, in time, we will learn about what 250 square feet looks like, about what 450 square feet looks like, so we can be on alert. So if I'm showing this home, we walk in this room, I look at my MLS sheet and I was like, well, the agent says this is 450 square feet, but I don't think it is. Okie doke. I'm going to run out to my trunk. I have a tool. It's a laser measurer, and it is so cool. I can hold my laser measure to the wall and point the laser to the other wall and hit a button, boop, and it'll tell me feet and inches from wall to wall. And then I take my tool to the other wall, hold it up, point it to the other wall, boop, hit the button, and I got feet and inches. Y'all, it does not take me time to verify it. If you or your buyer have a question about a room, now if it's about the whole house, we may need a second appointment to verify the measurements. But if there's a flag that goes up, we're going to help our buyer verify. And if and when you find a mistake, please make a courtesy call to the listing agent. Seriously, it takes me longer to go to my car to get my laser measure than it actually takes me to measure this room to help my buyer verify. So some of your wish lists for your new real estate tools, consider looking in to a laser measurer. They're cool. They're fun. So we're talking about measurements and what we need to know. And I mentioned something a few minutes ago, maybe you picked up on, that if you hire somebody, they need to make sure that they know the real estate commission's way to measure. As it turns out, there are several ways we can measure a house. So we need to follow the real estate commission's guidelines. And to make it handy, they provide us with a booklet called Residential Square Footage Guidelines. You may have this in Learn Test Pass if you want to read it. Again, this is more for you once you're licensed. And let's call the Real Estate Commission's guidelines on measuring your Bible for measuring residential square footage. This is it. So if you are going to measure yourself, you are following the guidelines. If you're hiring somebody, you're going to hand them the guidelines and say, if you don't do it this way, exactly this way, then I can't hire you. Remember, they're working for you. So you'll have access to this. This will be part of probably your new agent training. If not, you go to the commission's website and download it. It is so readily available. You're not going to be able to look at the commission and say, I didn't know. So there's some common questions we get about measuring. Well, can I just pull the tax records? Can I just look at the builder's blueprints? Well, this was listed before by another agent 10 years ago. Can I just use their measurements? And the answer to all three of these are no. We have to either measure ourselves or hire somebody to measure for you. I'm telling you right now, tax records and square footage are very rarely accurate. Very rare. So right out the gate, no, you cannot just look at the square footage reported on the tax records. Builder's blueprints are close, but it's still not the final product. There's adjustments and variations, accommodations that are made during building. So the blueprints may be close, but they're not going to reflect the exact final product. And taking information from somebody else's previous listing could result in a copyright infringement. It's not your listing. And how do you know that person was right? How do you know that that person measured correctly? So the only way that you can report measuring is either you measure or you hire somebody to measure for you. And by the way, new agents, whether you're going to measure or not, I do suggest you shadow somebody's in measuring a couple homes. You're going to be following the listing agent or following your BIC and watching what they do, because I do think you need to understand the process, whether or not you're going to measure yourself or not. Another good thing that measuring ourselves does for us is it could help us identify potential issues. I'm not saying the tax records are accurate, but it should be close. And if you have major differences, major discrepancies, then we need to go back and revisit. Maybe they finished a room, maybe they finished the unfinished basement. You're measuring the basement, but the tax records are not because they didn't pull permits. Maybe you're measuring the new room attached to the back of the house, but the tax records are not showing it because they didn't know about it because they didn't pull permits. So measuring, it allows me or my help to get into the home, to identify these potential issues, to look at some of these major discrepancies. My little red flag went up. So now I need to ask the questions. Start with the seller. I got twice as much square foot as the tax records. Did y'all finish the full basement? Oh, yeah, we did that a couple years ago. Smile sweetly. Now we got something to deal with, right? Now we got to talk about that unpermitted space. Another thing to understand with measuring, some space is considered above grade. Some space is considered below grade. Below grade space means that some part of that level, some part of that floor, often a basement, at least one side touches earth. If it's below grade, it's under the ground. At least one side touches earth. Above grade is all above ground. It's not touching earth. Above grade and below grade is a much bigger deal to the appraiser than it is to me and you. The appraiser's coming in, they're going to determine value, and below grade basements don't have as much value as above grade. When we get to unit 7, we're going to learn that you and I don't get to say that word value. That's an appraiser's word. So I'm not so much helping the seller buyer determine value. However, I do need to be able to identify below grade space to let specifically the seller know when the appraiser comes in, they're going to value this less than the above grade space. So let's take that into consideration when we're coming up with our listing price. Questions so far on measuring? All right, let's take 10. We come back, we got more to say on measuring. That cameras are coming on. Raj, that's really weird about your camera. Right, so I'm going to take attendance. Thank you. Let's talk some more about measuring. The big thing, if you guys are going to see a test question on this, my prediction, my gut tells me it's going to be on this. And this is actually defined what is living area. Yeah, no, you're good. Just keep doing what you're doing. Yep. Send me some stars. Defining what is living area could also be referred to as total living area, heated living area, but not every space under the roof counts as living area. And when I'm reporting square footage of a property, I can only report the stuff that is defined under the living area. You may have unfinished space, for example. That would not be under the living area. That would be something I would promote otherwise, like in my remarks, fully unfinished basement does not meet living area criteria, but you got a whole level or whatever of storage. So the only way I can count something as living area, also known as total living area, also known as heated living area. The only way I can count it is if I have these three things. Thing number one, it has to be heated by a direct source. I need a permanently installed heating system. Do not put a space heater in the room and say this room is heated. I need a permanently installed heating system. And please make note, that word only says heat. AC is not required. AC is a luxury. Now, I know we live in the state of North Carolina and we're coming off of summer and 99% humidity days at 90. What do we hit 100 a couple times? And you guys, well, I think AC is a luxury. Hey, listen, I hear you. AC is not required. Heat, directly heated source. Thing number two, the space has to be finished according to generally practiced building practices, general building practices. Specifically, what you and I need to know. The finished space has to have flooring. So we're on carpet or tile or wood or laminate. I'm not standing on subfloor. So we have to have finished flooring. I have to have finished walls. I'm looking at walls. I'm not looking at sheetrock or rafters. And I have to have a finished ceiling. And specifically, the ceiling height has to be 7 feet or more in order for it to count. So if you have a older home, you might be called to list a 100-year-old home. Y'all, 100 years ago, building codes were different. 100 years ago, we were all a lot shorter, weren't we? So it's not uncommon to find a 100-year home where maybe the bedrooms in the second story are like 6 foot, 6.25, something like that. If it's not 7 feet ceiling, I can't count that space. I can advertise it, second floor with 3 additional bedrooms, not counted in living area because of ceiling height. I can advertise it. But what I'm saying here is I can't count it in my living area, my total living area. If the space is a bonus room, maybe in an attic, and it's been finished, it's heated, and maybe the ceilings are sloped. Sometimes in attic space, you see those sloped ceilings. If we're in a room with sloped ceilings, in order for me to count it, it's got to be 5 feet from the bottom of the slope. So I have my slope ceilings. It's got to be 5 feet from the bottom of the slope. So if it doesn't meet the ceiling requirement, then we can't count it again. I can advertise it, but I can't count it. So it's got to be heated. It's got to be finished. And then the third piece is it has to be directly accessible. You need to be able to go from heated finished space to heated finished space to heated finished space, from room to room to room. Let's say, for example, you have a finished room over the garage. It's finished, it's heated, it's over the garage. The next question is, how do you access it? If to get to that finished room over the garage, you have to walk through the unfinished and unheated garage to get to those stairs, then I can't count it. Because I didn't go from heated finished. I went from heated finished to unheated, unfinished garage to heated finished stairs, heated finished space. Now, if the staircase is not in the garage, maybe you go through the kitchen into the laundry room, and at the end of the laundry room is a door, and that door takes you up to the finished room over the garage. That can count because it's directly accessible. You have to be able to go from room to room to room. Things like breezeways, catwalks, if you have rooms connected by a breezeway, because the breezeway is probably not heated or finished, then it can't count. We, hear my absolute word, must have all three of these things. And if anything is missing, then I can't count it in my total living area. Yes, I'm going to market and advertise the heck out of that finished room over the garage that you had to access through the garage. I'm going to promote the heck out of it because what a great selling point. What I'm saying is I cannot include it in my living area. Now, this is about the time of class I start getting a lot of questions. I have this space, or I know somebody that has this space. Does it count? Hold your questions. I've never seen the space, so I can't answer those questions, but I can turn that back around on you. Is it heated? Is it finished? And is it directly accessible? And if you answered yes to all three, then there's a really good chance that it could count. This is what's in the guidelines. This is what, if you're going to hire somebody to measure for you, this is what they need to be aware of. This is how, and there's other things too, which why we're just going to hand them that publication and make sure that they follow the commission's rules. There are so many companies out there now that offer to do measuring for you. They'll do pictures. I mean, they'll drone footage. I mean, they really take care of helping us with marketing and advertising. And I'd say for the most part, if they know that we're working with North Carolina agents, that they got to follow North Carolina rules. But to protect yourself as you are getting familiar with your person, hopefully you're finding your measuring guy and your picture guy as you're getting familiar with and working with these people. To protect yourself, make sure that you have hand them the guidelines and that they know to follow them. There was a disciplinary action either earlier this year or late last year. I don't know why people do what they do, but the agent, the broker, hired an appraiser. Sometimes we hire appraisers to help us measure. Think of like a truly unique home. Most of what we see is pretty measurable. You and I can handle this, but every once in a while you get into a floor plan or a design that's truly unique and what all might be in our best interest to have the appraiser come in. So this broker had the appraiser measure, provided their report, gave the broker the living area, and the broker somehow, for some reason, decided that that wasn't right. I'm going to put my own numbers in. Why did they waste their money on hiring an appraiser? I don't know. But they went against what the appraiser, for some reason, I don't know why. But anyway, they faced disciplinary action because they reported inaccurate and incorrect living area. So we're getting a listing. Yay, we're going to go measure a house. I am no artist, so please bear with me. But I think that we can get a kind of a good idea here for what we're looking at, how we want to measure. So you're going to call to measure a home. Isn't it pretty? Okay, so in this space up here, maybe the garage is up here, and then down here is the porch. Maybe part of the porch juts into the home. It sets into the living room, a setback porch, for example. But when we first measure to determine total living area, we always start outside. So when we measure, we're going to start outside and we're going to go from corner to corner to corner. We're going to work our way around the house, and you got all kinds of cool tools to help you with this, or the person that you hired. So we spend some time outside, going corner to corner to corner, point to point to point. We measure everything under the roof. By the way, y'all want a free tip for the day? If you're going to measure yourself, get you some rubber boots, because we're getting into bushes and shrubbery and things scurry and slither. So get yourself some rubber boots. There's your free piece of advice for the day. Some of you just want, nope, that's it. I'm hiring somebody. Lots to think about before you make that decision. So you or the person you hired went in and they measured outside from corner to corner to corner to corner. And then we have to go inside and measure the stuff that doesn't count, or deduct, I should say, deduct the stuff that doesn't count, deduct the stuff that is not finished, not heated, and not directly accessible. So we start outside to get everything under the roof. And then we go inside and deduct what does not count, what doesn't meet those three musts: finished, heated, and directly accessible. Of course, there's always some good exceptions. Let's say you're measuring a home that you can't get to the outside. Maybe the basement is totally underground. You don't see any part of the basement. So you can't measure the basement unless you dig into the ground. We don't want you to do that. Maybe you have like a Tudor home, a 2-story home, where the second story is a different size, a different dimension than the first. I don't want you guys trying to measure the second story from the outside. Never try to measure anything whilst being on a ladder. Safety always first, you guys. So if you have this 2-story and the second story isn't as big as the first, we can still measure outside on the first floor. So we can go corner to corner on the first floor. And then we have to go inside to measure the second floor. And measuring the second floor inside, we're going to measure the exterior walls. An exterior wall means on the other side of the wall is the outside. An interior wall, the other side of the wall, is another room or a hall or a closet. So we're going to go inside the second floor. We're going to measure the exterior wall from the inside, and then we're going to add 6 inches to account for the width of the wall. So on average, with siding, rafters, insulation, and sheetrock, that wall can be about 6 inches. So if you cannot get to the outside, then you go inside. We get those exterior wall measurements and we add 6 inches. The exception to this is if we're measuring a condo. Condo owners don't own that wall. Condo owners own from sheetrock to sheetrock, paint to paint. So if you're measuring a condo, we just measure interior only and do not add 6 inches. if you're going to hire somebody to measure for you, like we said, they need to have the experience. There's so many out there that'll do it, a general contractor, an appraiser, or like we talked about, these companies that do this for a living. No matter who you hire, no matter who you have do it, they need to be aware of the guidelines for stuff like this. I have a video in just a second. We're not going to take the time to watch it just because this isn't a heavily tested unit. But I do have a video I'm going to drop in the chat for you guys, maybe on the next break, for you guys to look at your own time, if you choose. And the video, it was done by the Winston-Salem Board of Realtors. And it's actually a series. I think it's a 5-part series. But the first video is the overview, the overall of measuring. What you need to know for your test is in the video, but there's also more than what you need to know for your test. So you're going to hear things such as finished and heated, directly accessible, things like that, the things that we've gone over. But I do think the video gives us the visualization, because it goes through 2 gentlemen actually in the practice of measuring a home. So I do think the video, they did a very nice job of it. So I am going to put that in the chat in just a minute so you guys can look at that at your own time. And it's only like 8 minutes. So I do think to look it over, it'll help solidify this conversation. It'll help solidify. It's awfully hard for me to talk about it. The best way I can teach y'all how to measure a house is if we were all to take a field trip out and go measure a house. And unfortunately, in our short time together, it's not going to happen. So hopefully the video will help. Questions? I'll never forget the first house I measured. My first listing that I measured. And I got a general contractor on my team. I can't tell you the benefit of having one of those on speed dial. So I went to measure a house and I took a general contractor with me. I was like, oh, this is going to be so easy. Man, he was all about some tough love. He didn't do much but observe and watch. Julie, do this. Julie, don't do that. We were there forever. I never thought I was going to leave that home. The second home I measured went much better than the first. The third one I measured went much better than second. The more you do, the more familiar with it the easier it gets. Again, as you guys are getting started, your BIC may want you to shadow. They may want you to hold the dummy end of the measuring tape for your listing agent. Watch what they do. If you choose to measure yourself, the first couple listings you get, your BIC or a seasoned agent in the office, somebody that's very familiar with measuring, may accompany you, and now they're holding the dummy end of the measuring tape. But I say all that to say, don't expect measuring skills to be perfected in the first home or two. It takes time, it takes practice. All the while, the important thing is that you guys have that guidelines book in your hand while you're doing it. Questions? So yeah, we're going to use our outside measurements whenever possible. Safety first. Sometimes it's possible, sometimes it's not. So if we can't use outside measurements, that's when we go inside, measure those exterior walls and add 6 inches. The exception to this is the condo. Condo, you do not add 6 inches because condo owners don't own the exterior wall. Condo owners only own from paint to paint. I think a good rule of thumb with our 3, finished, heated, and directly accessible, if you can walk on it and it counts heated, finished, and directly accessible, then you can probably count it. So think about maybe a 2-story home where the foyer, the entryway, is both stories. It's an open and it's big. It's 2 stories tall. The measurements on the first floor are going to be more than your measurements on the second floor because you have open space on that second floor. So because you have that open space, it goes from floor up 2 stories. You're not going to have space there to count. So our first level of measurements will be more than the second level, taking into accommodation, that space, like the cathedral ceilings, things like that. What about stairs? What about bonus rooms? What about attics, bay windows, and garages? What's our favorite answer? It depends. Is it heated? Is it finished? And is it directly accessible? And again, if you can answer yes to all three. Stairs get interesting. But for the most part, stairs are going to count twice. Again, I can't draw. But if everybody could humor me just for 1 second. If you use your imagination and squint, can we see a set of stairs there? Okay, good. So we have our stairs, and actually they're going to count twice because I'm walking on them. Let's do this. I'm walking on them on the second floor. And I also have the space underneath them. So I'm walking on them on the second floor, and then I have the space underneath. So generally speaking, stairs might count twice. Is it finished? Is it heated? Is it directly accessible? We got to put our eyes on it. When it comes to attics, remember our ceiling height, 7 feet. A lot of finished and heated, directly accessible attics may have sloped ceilings. So that bonus room upstairs or whatever might have a sloped ceiling. With those sloped ceilings, as long as it is 5 feet from the bottom of the slope. Finished, heated, and directly accessible, then yeah, the attic can count. Bay windows are part of the house. They usually come from the dining room or the breakfast area, things like that, a kitchen-ish area. And a lot of times bay windows jut out from the home. So you have the wall and then you have this little window that goes beyond it. Do bay windows count? Remember your ceiling height, you guys. Some bay windows you can actually walk out into. Other bay windows may have a little bench or something that you can't. It's got to be finished. It's got to be heated. It's got to be directly accessible. And we have to have 7 feet ceiling height no matter what. A question comes in, is under the stairs measured only if it's accessible? There are some variations, and one of those variations might be like the utility room. It might be the area under the stairs, just for simplicity. I think overall that area under the stairs, we're not looking at a lot of square footage. So brokers are allowed a little wiggle room for discrepancy, and that's where that under the stairs would count. Even if you can't access it, they give us that little bit of wiggle room. It's just easier for us. If you have a utility room that has your furnace and your water heater and your fuse box, you might have a room just for those, and maybe there's not a floor. Maybe you're walking on subfloor or prime. Again, there's some wiggle room there. They're going to let that count. It's just easier. And that room's not going to be that big that it's going to affect the overall square footage. So here's the deal, you guys. The questions I need you to ask, and comes back to these. I hope we see that this is important. Now that I have the total living criteria, our MLSs require the total living area. So one way or another, I got to get the total heated square footage. Now the next question is, what about the individual rooms? And that's a conversation with you and your BIC. That's a conversation with you and your seller on how you're going to promote and advertise their home. Some are okay with just the total living area. Some like the room dimensions because buyers may look at that. How big is this kitchen? How big is this dining room? I'll share with you guys, I had buyers once. Remember, if it's important to them, then it's important to me. So I had buyers once, and she told me very early in our relationship that she has large dining room furniture, and she needs a dining room big enough for her dining room furniture. As her agent, did I have a material fact on my hands? Yeah. If it's important to her, then it automatically became important to me. And I'll tell you, just by looking at the dimensions of the dining rooms and some of these properties for sale, we could rule out those showings. We knew before going into it that the dining room would not be big enough for her very large dining room furniture. If it's important to them, then it's important to me. So yeah, you're going to make adjustments. We're going to remove the porches. We're going to remove any unfinished areas such as the garage. Maybe that unfinished basement. Again, I can advertise attached 2-stall garage, but I'm not including it in my total living area, my total heated square foot. Questions? So we've seen this slide before. We saw this back in unit 2, and this is addressing our area. And we talked about our length times width equals square feet. Verbiage counts. So maybe we're measuring a kitchen, in which case I go into the kitchen and I get the length of the kitchen, I get the width of the kitchen, and that'll give me the square feet of the kitchen. When you guys look in MLS, all you see is the dimensions. So if it tells you, for example, in MLS, and I'm going to make numbers up, that the kitchen is 17 by 14 for, just making numbers up. There's your dimensions. There's your formula. So we can take length times width. Remember, feet and inches are 2 different things, but we can get a rough idea when your buyer looks at you and says, I wonder what the square feet of this kitchen is. If we have the dimensions, we can help them figure that out. We also use this formula when we were talking about measuring land. And we use different verbiage, but we use the same formula. So when you're talking about land, maybe they say length times width, maybe they say front foot by depth. But either way, we're looking for the square feet or the area. That's our review. Please make sure you go back to unit 2. We continue this. There's another shape. Now that we're inside, now that we're measuring the homes, there's another shape that we might come across. And that other shape is that of a triangle. The good news is when I'm measuring a home, when I'm measuring the kitchen and the dining room and the bedrooms, the good news is I only know how to measure 3 shapes: squares, rectangles, and triangles. Not all rooms are perfect squares and rectangles. So we may have to take our graph paper with us and break that room up into shapes that we can measure. So triangles very well may step in to fill the gap. And the formula for the triangle, I think it's better to see. We're going to take length times width to find square feet, but now we're also going to divide by 2. So putting semantics aside for just a second, can everybody humor me? Can we all agree that a triangle is just half a square? So if I take my square, length times width, and I divide it by 2, I'm now looking at my triangle space. And again, you sometimes have to make shapes. Get you some graph paper if you're going to measure yourself, but you sometimes have to make shapes because this is all we know how to measure. We talked about unique properties that may not be this easy. If you're getting out of squares and rectangles and triangle shapes, then this could be a good time to call the appraiser, get their expert opinion on that measuring. I showed a house once. It was an octagon shape. So it was like the shape, if you did a drone footage and looked down, it looked like a stop sign. It was that 8 sides. And that home I was showing was actually to one of my girlfriends. And she looked at me and she said, how would you measure this? And I said, I would not. I would call an appraiser. This got out of my realm really fast. So stick with the shapes we know. And no, not all homes are perfect squares. Not all homes are perfect rectangles. So utilizing this. Another thing I want to introduce you guys to is some of the verbiage. Let's go back to land. Where's house as well? Excuse me, house and land. So just some verbiage. There's cost per square foot, and then there's cost per acre. That word per is a fancy way of saying divide. So if we want to know the cost per square foot, what we're trying to determine is how much does each square foot cost. If we're trying to determine cost per acre, then what we're trying to determine is how much does each acre cost. Builders use this verbiage, developers use this verbiage a lot. Some builders price their homes for sale based on how much was the cost per square foot. So let's say, for example, just to play this out, I don't think we need to know this math, but we need to understand the verbiage. So let's say you have a home and the cost of the home is 350,000. And this 350,000 home has, I'm making numbers up, 4,500 square feet. So cost per, so I take my cost and I divide by 4,500, and I learn that every single square foot costs 7.77777777. So the cost per square foot of this home would be $77.78. Same thing with acres. So being familiar with the verbiage. Questions on this? And remember, when you're looking at cost per square foot for the home, when you're pricing it, for example, when the builder's trying to price it, cost per square foot for the home is just for the structure. Don't forget to add in what the land is going for as well. The land has value in addition to the home, in addition to the structure. Land measurements, there's that front foot again. We saw this in unit 2. So the front foot is the length of the property. The front foot is the part that runs along the street. The thinking here is the front foot is the most desirable part of the property. And that's usually the front of the house. That's usually what faces the street. So when you see land dimensions, maybe we see something like 250 feet by 500 feet, making numbers up. When you see those land dimensions, those land measurements, the first dimension given is the length, is the front foot. So we're looking at either length times width or front foot times depth, all to find square feet, all to find acres. So let's have some fun. You're out looking at property. Your buyer wants to know what the land measurement is. They want to know how many square feet. You look at your MLS sheet and it tells you that this land is 800 by 1800. What's the square feet of this land? And you can share that in the chat if you want. I'm not looking to spend much time here, but what's the square feet? Grab your calculators. So when I take the front foot of 800 times the depth of 1800, I get a whole bunch of square feet. We get a lot that is 1.44 million. We'll stick with that. But we get a lot that is this big. What's my magic number if I wanted to convert this lot to acres? Let me see everybody's mouths move. What is that magic number? Four little old ladies driving 35 in a 60, 43,500. So your buyer says, I wonder what the square feet is in this property. And you tell them and they say, wow, my agent really knows her stuff. And then they say, what are the acres? So now we take that square feet and divide it by that magic number. And I'm getting about 33 acres, give or take. Again, it all comes from that magic number of 43,560. So this big old tract of land is about 33 acres. That's a big tract of land. Questions? So we got a couple math problems, tying all this together. We got a couple math problems. I think there's two we're going to work together. And then I got two for you guys to do on your own. So again, area math, we started in unit 2. We're picking up, we're going to finish it in unit 5, tying it all together. So let's talk about Brent. Brent owns a lot that measures 600 by 500, and he wants to sell the lot for $500, $520 per front foot. What is the list price for the lot? I don't know about y'all, but I'm a visual person. And when I talk about Brent's land, I need to be able to see it. So here's my land. Here's the road. The first dimension given in the formula, in the dimensions, the first one given is the front feet. It is the part of the road that runs parallel to the road, the part of the property that runs parallel to the road. So then the next number given is the depth. If we were to stand with our back to the road, how far deep is the lot? How far back does it go? So the first thing we need to do is figure out length times width. The first thing we're going to do is figure out the square footage. And I see that this land has 312,000, let's label my work, square feet. No. That's why I don't do stuff off calculator. Hold up.
Wouldn't that be 300?
Yep. Thank you. I don't go off calculator, and this is why. My little brain, y'all. There it is. Thank you. So 300,000 square feet. Okay. The problem tells me that this lot is going to sell for $520 per front foot. So what it's telling me in this case, watch that word per. What it's telling me in this case is that I know each square foot costs $520. I know each square foot costs $520. So now what we need to work to, we're kind of working backwards here. And what we need to work towards is what would the list price per square foot be? What is the list price per square foot? So I know I have 300,000 square feet. I know that each square foot costs $520. So if I take, no, per front foot. Sorry, guys. See, when you read the question, per front foot. So I know each front foot, there it is, costs $520. So every single front foot costs $520. I have 600 of those things. I have 600 front feet, each one costing $520. So based on that, we could give a list price of $312,000. So we first had to determine, we really didn't have to determine square foot here, did we? That was a bonus step. What we were really looking for was the list price for the lot, and we're looking at $520 per front foot. Questions? Be prepared. They may take it a step further. They may not ask you about the list price. They may ask you how many acres. So again, being familiar with how to convert acres to square feet to acres, knowing that 43,560, so we can convert the two. So now that I have 300,000 square feet, we would just take that 300 square feet, divide it by 43,560, and that gives me 6.89 acres, give or take, plus or minus. Big thing here is converting square feet to acres, acres to square feet. Questions? Let's look at another one together. Sophie owns a lot that measures 200 by 800. She purchases 2 adjoining properties with road frontage on the same road. Lot 1 is 800 deep and has 560,000 square feet. Lot 2 is 800 deep and has 720,000 square feet. How many front feet does Sophie own? Again, this is where I think pictures help. This is where I think of visualization. And what I'm actually looking at dealing with is 3 different lots. And we're not getting bogged down on accuracy here. You don't have time for that. What we're looking at is 3 different lots, all on the same road. I just took the information from the problem, and I think pictures so help with area problems. She owns 1 lot that measures 200 by 800. And she purchases the 2 adjoining lots with road frontage on the same road. Lot 1 is also 800 deep and has 560,000. Lot 2 is 800 deep and is 720,000. So again, just taking the information, I haven't picked up a calculator yet, but all I've done is taking the information from a problem and putting into an image, putting into something that I can see. So the question wants to know is how much front feet does Sophie own? Well, as of right now, I only know the front feet from the first lot, the one that she owns of 200 front feet. So we need to find the front feet of the other 2 lots. And we can do that. We used our length times width equals square feet, but we can also take that information and we can convert it into a t-bar, because you know what? I know I have to divide something right here, but I don't know exactly what it is. So if I make a little tweak on my t-bar, just a little adjustment, we can use the t-bar of length times width with the square feet on top. All we're pretty much doing here is saying A times B equals C. So I have the square foot in the depth or the width of the second lot. So I know the second lot, my square feet is 560. I'm solving for the length and it gives me 800. Back fourth line in the t-bar means divide. So I take 560,000, divide it by 800, and I get a length or front feet of 700. We're going to go through that exact same exercise on lot 2. Again, I know the square feet and I know the width, but what I need to find is the front foot. So again, the problem tells me I got 720,000 square feet. We don't know the front foot yet, but what we do know is the depth. Back fourth line means divide. So we'll take 720,000 divided by 800, 720,000 divided by 800, and that gives me 900. The picture helps me. I suggest drawing it out, at least as you're learning, so we can actually see what it is that we're doing. I mean, this is a big problem. And I think, I don't know. I'm not going to say you're going to see one like on this. I'm not going to say you're not either. I think this could be type of problem, could be a great candidate for an area problem on your exams. So now that I know all my front feet, the lot that she owns is 200 plus the 2 she's going to purchase. Now that we know our front feet, We get back to the question, and the question wants to know, how many front feet does she own? So she started with 2. She purchased one with 800 front feet. She purchased one with 900 front feet. So total, our girl now owns 1,800 front feet. Back to the basics. It's all about the basics of length times width equals square foot. Questions? Can I erase? Again, example, I think worst case scenario. I do. I think worst case scenario. But it's all about building up to it, getting the basics. So here you go. Tell me in the chat A, B, C, or D. About another minute, and then we're going to talk about it. Okay. Let's see what we have. Let me see your mouths move. Shout at me. What's the very first thing you did? I'm seeing a lot of words come out of mouths. The first thing I want you to do is always read, read, especially when it comes to math. Read questions, period. But when it comes to math, please, please, please read. So how many acres are contained in a rectangular land parcel that has a length of 175 feet and a depth of 685? Again, I'm a visual person. If you don't want to take the time to do this on your scratch paper, you do not have to, but it helps me. And I do suggest at least starting with drawing it out. Maybe you can wean yourself off, but at least if we start so we can see what it is that we're talking about. So I got a length or a front foot of 175 feet and I got a depth of 685. Length times width. 175 times 685 tells me that the square feet is, I'm getting 119,875 square feet. So how big is this lot? 119,875 square feet. The question though wants to know about acres. So now that we have square feet, we need to convert square feet to acres. And we do so using our magic number of 43,560. So now that I know my square feet, I'm solving for acres. And if you will allow me a minor tweak in the T-bar, we can use that 43,560. Back fourth line in the T-bar means divide. So we're going to take 119,875 and divide it by 43,560. How many acres are in this lot? 0.75. Step one was to find square feet. Step two was to convert square feet to acres. Using that number, they will not give you on your test. 43,560 questions. Can I erase? Of course, my question is always, my rhetorical question to you guys is always, if you didn't get it right, do you see where you went wrong? Because that's how we learn, you guys. Sometimes we got to make mistakes. Sometimes we got to fall down before we learn how to walk, right? So sometimes in math, we got to get it wrong to learn. And that's all I ask is we see where we went wrong. And of course, the other thing I ask is that you guys practice, practice, practice. All right, one more, and then we'll see about a break. Tell me in the chat, A, B, C, or D. Another minute, and then we're going to talk about it. Let's see what we got here. So I got a lot with a depth of 80 feet and an area of 4,800 square feet was sold for $350 per front foot. What was the total sales price? So I'm not totally sure what this is saying, but what I do know, if I take a minute and draw me a little picture, I can look at what it's saying. So I got a depth of 80 feet. I got total 4,800 square feet. The problem wants to know if we sold it for $350 per front foot. So before I can proceed, I have to find that front foot. So again, if it's easier, I mean, A times B equals C is our formula, or if the T-bar helps you to see, I know I got to divide something. So the T-bar allows me to see something, and I'm going to solve for the front foot, and I got a depth of 80. So quick little calculation. That fourth line means divide. So I take 4,800 divided by 80, and I have a front foot of 60. Now I know that. Questions so far? Square feet divided by depth gives me front foot, 60 front feet. Then the problem tells me it sold for $350 per front feet, which means every single front foot costs $350. Every single front foot costs $350. We just determined that we have 60 of those. So when we take price per front foot times the number of front foot, we get our cost of this lot, which is 21,000 for A. Questions? My race. All right. Let's take 10. Come back. We're going to wrap this up and then we're going to start with some financing. So let's take 10. And we're back. Welcome back. Weird. So I'm going to take attendance. You guys pull your chats up while I'm doing that. And I am getting ready to, as soon as I take attendance, I'm going to throw the link to that measuring video that I talked about. So it's the fundamentals of measuring, the links in your chat. Please don't watch it now. I would consider that a distraction. But again, it's only like 8 minutes. And I think they did a really nice job of showing what measuring is all about. And that's hard to do. Even if we were face to face in person, it'd still be awfully hard to do. So the best way to learn sometimes is to do. And I think that video gives you pretty good insight of what to expect. Remember, there's more in that video than what you need to know right now, ever. What you need to know is in that video. So I think it answers a lot of questions. I also think it helps prepare you for exam and for, the real world. If you did not get the link to the video, and again, you may want to save it or bookmark it or something to watch it later. If you did not get the link in the chat right now, or later you realize you lost it, all you guys ever have to do is just reach out to me. Shoot me a quick message and say, Julie, I need that measuring video, and I will respond with it. Any questions on measuring? We're officially done there. Heated, finished, directly accessible. Also, now that we are done with measuring, I want to bring your attention to Learn Test Pass, and specifically in Learn Test Pass. After the Unit 5 material, there is a Part 1 exam. So in Learn Test Pass, after the Unit 5 material, there's a Part 1 exam. And this is a culmination exam from the first 5 units. This is for you to practice. There's no requirement. You don't have to do this. Boy, when you have a bad day. Oh, here it is. Okay. That was not technology. That was me. So I think this is a great way to kind of recap, see where you are, like a snapshot, where we are at this point at this time. So again, it's in Learn Test Pass. It's Part 1 exam. I recommend it. I recommend you do this because, guys, we're getting close. We're only, 3.5 weeks away before you guys start taking a test. So please be watching your time. I mean, October is next week, if that's hard to believe. I know another thing that we have in the back of our brains is the midterm exam. The midterm exam, I'm not going to spend a lot of time talking about it right now, but I will say the midterm exam, thank you. We're going to make the midterm exam for you available starting next Tuesday. So you have like a week to get the first 6 units. Your midterm exam is on units 1 through 6, and I'm not trying to rush through 6. So I want to make sure we have plenty of time to do it. You will take the midterm exam on your own time. the midterm exam will be open for a week. So starting on Tuesday, starting a week from today, the midterm will be open for a week. I will email you the link. We'll talk about the specifics. I don't want to get bogged down in it now because we're not quite there yet. So we will spend time next Tuesday talking about that exam, and it will be available for you after class next Tuesday. Is the midterm multiple choice? Yes, all of your exams. And the whole point of the midterm is hopefully to help prepare you for that state exam. So we're trying to mimic those exams. So yes, it will be multiple choice. More on that, just make a note on your calendars starting next Tuesday. And we will talk about the midterm exam on Tuesday. The other thing we're going to talk about next Tuesday, a week from today, is the application process. How do you submit your application? How can you go take your state exam? Where do you go to take your state exam? The costs, all that's involved with that process. So we will talk about that next week, next Tuesday as well. So we're getting questions on the midterm. Awesome. Is it just one attempt on the midterm? Yep. But remember, I'm not looking for pass or fail. All I'm looking for is that you attempt the midterm. The Learn Test Pass quizzes you can take over and over and over and over and over again. The midterm is a one and done because we're mimicking that exam. So more on that next week. Just let you guys know where we are. So with that being said, this is going to sound a little strange, but you know what I want you guys to do right now? I want you to put aside your broker hat. We're going to put real estate aside for a second, a couple units, and we're going to focus on some other aspects that revolve around real estate. So unit 6, the best way I can tell y'all to get through unit 6 is to put on your lender hat. Think like a lender. Y'all didn't know you were signing up for this when you signed up for real estate school, right? We've got to understand the lending process. We have to have a fundamental understanding, a foundation of it, because we're the ones working directly with the buyers that are getting the new loan. We are the ones working with the sellers that need to pay their loans off so they can sell, so they can convey. So unit 6 is our financing unit. And we're going to think and we're going to talk through the eyes of a lender. So that's a basic understanding of the lending process. So we're going to start with defining some terms and concepts. We're going to specifically differentiate between a mortgage and a deed of trust. Same document, names are used interchangeably, but there is a difference between states that use a mortgage and states that use a deed of trust. So we will differentiate between those and which one is North Carolina. We're going to talk about the rights and obligations. Both parties in this have duties to each other. So we're going to talk about the lender's rights and obligations to the borrower. We're going to talk about the borrower's rights and obligations to the lender. Who the lender calls the borrower, you and I call the buyer. This is the person that's originating the loan. So let's talk about financing. You want to buy a house, you're not a cash buyer, you're going to get some financing. And when you're financing a home, there are two main documents. There's a lot of paperwork, but there's two main documents when financing between the borrower and the lender. The first document is the promissory note, also known as the mortgage note. The note is the IOU. You, the borrower, owe the lender for the loan amount, whatever you borrowed to purchase the home. And the lender's going to make you sign an IOU promising to pay them back. The promissory note is also going to spell out what happens if you do not pay them back, if you stop making those payments, and we will talk more about that. So this is the IOU. It's the contract between the lender and the borrower. The other document is the security instrument Some states call it a deed of trust, some states call it a mortgage. We will differentiate between the two, but it won't matter what you call it, it still serves as a security instrument. The deed of trust is what gets filed with the Register of Deeds for public records. The deed of trust is what can be available, what can be found for public records. The promissory note does not get filed in the public records. So the deed of trust secures the lender's interest. People are shady sometimes, you guys. And if the lender didn't have the secure document recorded at the Register of Deeds and the public records, the shady seller could try to sell this from out underneath the lender, never telling the lender. Property conveys, the new owner's not going to pay the lender. You with me? So the one way that the lender can protect their interest, protect themselves, is by recording the deed of trust. My homeowners on the call can feel this. So you bought a home, yay! And you go to the attorney's office and you do your thing, and the attorney finishes, the attorney finalizes it. That whole process is coming as well. But the attorney does their thing, and to solidify the deal, you know it's a done deal when the buyer's new deed gets recorded. Deed is evidence of title. That's coming as well. So first thing they do, how they solidify this transaction, they record the buyer's new deed, proving that they are the owner of record. And literally in the next breath, once they record the deed, then they immediately record the deed of trust. This is at the request of the lender, because remember, lien priority, superior liens first. All other liens after that are paid in the order in which they recorded, except for the mechanics lien. So the lender or the attorney on behalf of the lender files the deed of trust almost immediately after the deed is recorded to secure the lender's interest. Sometimes if you buy a home, the deed of trust is filed before you ever get your keys. It all happens that fast. And again, we're going to go through the entire contract to closing process, the attorney's responsibilities, much more to come. So the two main documents, the note and the security instrument, two different things, both protect the lender, both are the agreement between the lender and the borrower. I have to change some of your thinkings. We got to make sure that we are down with the verbiage, that we understand the verbiage. The mortgage, we all talk about, well, I paid my mortgage this month, I sent in my mortgage payment. Change your thinking. The mortgage or the deed of trust is the lender's security instrument. You're paying on your mortgage. You're not paying the mortgage, you're paying on the mortgage. So I know the common verbiage out there, but I need you to understand when you see mortgage on your exam or deed of trust on your exam, it's not referring to the monthly payment. It's referring to the security instrument. It's referring to the document between the lender and the borrower, the agreement, that security instrument between the lender and the borrower. Another financing term is hypothecation. This is pledging the property to the lender as collateral. So that security instrument, that mortgage or that deed of trust, the lender needs something, y'all. They're not going to take the borrower on their signature. I promise to pay you back. Where do I sign? Again, people are shady. So the lender's got to protect themselves. And one thing that the borrower does in all that paperwork is they pledge the property. They allow that deed of trust, the lender, to use the mortgage as collateral, as security. And in so many words, it says, you're going to pay me back regularly, X amount over the next how many years. And if you stop, if you fail to do that, then eventually the lender has the right to take the property, sell it to collect their money. More on that. Before we get much deeper, though, let's define the parties. We've been talking about lender and borrower, but for our exam, we need to address them differently. So I got the mortgagor versus the mortgagee. The mortgagor is the giver of the mortgage. The mortgagor is the borrower. Can we hear a play on words? Mortgagor, borrower. The one that is giving the mortgage, the one that is giving the security is the mortgagor. It is the borrower. And they've given that security to the lender, who's referred to as the mortgagee. They are receiving that security instrument. So the borrower is the mortgagor. The mortgagee is the lender. Some people see this lender has two E's in it, mortgagee has two E's in it, borrower has two O's in it, mortgagor has two O's in it. I don't care how you see it. Flashcards, whatever. Play on words. Questions so far? So when it comes to the mortgage or the deed of trust, there's some essential elements. Let me first talk about what essential elements are before we look specifically at what they are. Essential elements are kind of like required ingredients. And in order for a judge to determine the validity of a document, is this document valid? The judge is going to first determine if the essential elements are present. So with essential elements, and we're going to talk about this again in contracts, a couple other places. With essential elements, again, it's the judge determining the validity of the document. And I always think of essential elements like cake ingredients. It's mean to talk about cake right at lunchtime, but has anybody ever baked a cake? Has anybody ever eaten a cake? So we're all familiar with cake, right? Okay. There are certain ingredients, right? When you're baking a cake, don't you just have to have flour and oil and an egg and maybe some water? There's just things that you have to have. Baking a cake without flour, you don't have cake. Having a deed of trust, missing an essential element, missing a required ingredient, then you don't have a valid deed of trust. And that's what the essential elements are addressing, is the validity of a document. So if the judge is handed a deed of trust and the judge is asked, is this valid? The judge is looking for the flour and the eggs and the water, etc. Specifically, the judge needs it to be in writing. The judge needs competent parties. The borrower and the lender are the parties, and both parties need to be competent, sound, sober mind, etc. The judge is making sure that the deed of trust is for a lawful purpose. We have our legal description. We talked about these back in Unit 2. So that legal description, property description, delivery and acceptance by the borrower. I'm sorry, by the lender. The lender has to show that they've accepted this deed of trust. And one way that the lender can show that they've accepted it is because this document is on record. It's on record for public notice, which would be evidence that the lender has accepted it. The deed of trust has to refer to the promissory note. It has to refer to the IOU. And then the mortgaging clause, is going to be a part of it. There's got to be provision in there about what happens when you pay it off. What happens if you don't pay? How is this mortgaging going to affect the parties? So again, if we were to go stand in front of a judge and hand him a piece of paper that says deed of trust on it, the judge's first question is going to be, is this a valid document? And to answer that question, they're going to make sure that they have these essential ingredients, these essential elements. Checking the validity of the deed of trust. I hear this a lot from my buyers. I've heard this over the years. I mean, in some cases, we just closed on your new home like last week, and now all of a sudden my buyers are getting notice from a new lender that their note has been sold. This happens fast in some cases. And my buyers, I had one call me once and said, my lender sold my loan. I said, probably, yep. I said, I thought my lender liked me. Baby, your lender loves you, but your lender may not service the loan. So whether or not your loan can be sold to another bank or it's going to remain with the originator, the one that you originated with, depends. If this is a negotiable note, then it may be able to be sold to another lender, to another bank. If it's non-negotiable, then the lender intends to keep it in-house. They're not going to sell it. So I'm going to say the majority of our lenders do sell. And we're actually going to talk about why they do that and how that looks. That's coming. But some lenders, and actually I'm hearing more and more of lenders, are keeping those notes in-house. So the answer is, it depends. Buyers, borrowers should always be encouraged to talk to 2, if not 3 lenders. Kind of like real estate firms, not all loan officers are created equally. They all offer different products. They have different requirements, different application process. They're all a little bit different. And the only way your buyer can determine if they have the right lender for them is to shop around so they have something to compare. And if this is something that's important to your buyer, then we're going to help them recommend to them lenders, because we know lenders, we have lenders in our tool belt, help them recommend lenders that do not sell the note. More on that, a little teaser there for you. With the promissory note, with the note comes some clauses. So we're going to talk about some common clauses that are often found, not always, because they're all just a little bit different. But these are some common clauses that we're going to find in the mortgage note or in the deed of trust. The first clause is called the acceleration clause. If the borrower stops making payments, the borrower misses a payment, maybe 2, maybe 3, maybe 4. However many payments the promissory note allows the borrower to miss, there is no right number. It's all got to be spelled out in that promissory note. And it is. If you miss X amount of payments, then we're going to start the foreclosure process, for example. So what the acceleration clause does, in the event that the borrower's missed a payment or 4 or whatever, the acceleration clause allows the lender to accelerate the due date. And the lender may say, look, I broke this down over 30 years and allowed you to pay me a little bit each month for the next 30 years, but you broke our promise. So now I'm going to accelerate the due amount. I want the whole thing due. If you can't come up with the whole amount due, then I'm going to start the foreclosure process. We're accelerating when and what is due because the borrower failed to keep up with their end of the agreement. If you can come up with the whole note due, you can avoid foreclosure. Another clause, by the way, there's 2 borrowers we're talking about. One is your buyer that is originating the new loan, but oftentimes the seller also has a loan that they're still paying on. And that seller is the borrower of their loan. And it's not uncommon to see a clause called the alienation clause or the due on sale clause. The due on sale clause tells the borrower, when is your payment due? It is due on the sale of your property. So if you sell your home with an outstanding loan, the whole amount will be due as part of your proceeds. Before you can get paid, you got to pay off that lien. That will release you part of your proceeds, and that'll take care of that loan. So the alienation clause, you've chose to alienate yourself from the property because you've sold it. Many of our home loans are 30 years. Not many of us are staying in homes for 30 years anymore. You know, once upon a time ago, you got married and then you bought a home and you lived there for 30, 40, 50, 60 years. Today, y'all ready for this? On average, across the country, they say we're moving every 8 to 10 years. Why? Moving sucks. It just seems like an awful lot. So a lot of lenders know when you take on this 30-year loan, you're not around for 30 years. That's just not what we do today. So they have this due on sale clause that requires the whole amount due on the sale of the property when you sell the property. So here's a little note for us not to confuse the two. The acceleration clause is going to be used on default. You've missed X amount of payments. We're going to accelerate the whole note due. Compare that to the alienation clause. You choose to sell. You're not forced into foreclosure. You chose to sell, and you got to pay off the whole thing before we can move on. Questions so far? Another term often found in promissory notes is called a defeasance clause. When we see this word, make a note. I'm defeating the loan. Y'all, this is what we get up and go to work for every single day. You pay that loan off, you have defeated the loan. The lender will return legal title once they've given that final payment. We're going to talk about the lender's legal title, what the borrower has, all that's coming. You made that last payment, you have fulfilled your promise to the bank. So the defeasance clause will kick in, and the lender will often file a deed of release. That deed of release releases you from the deed of trust. So when the attorney does their public search, they can see the chain of events. They can see that you took the loan out when you bought the property. And then fast forward, they have a recorded deed showing that it's been paid off. You have defeated the loan. Another term often found in a promissory note is a prepayment penalty. Whether or not the lender will charge a prepayment penalty has to be spelled out in the loan. Prepayment penalty would be charged if you pay the loan off early. Maybe you make your payment more than the required amount each month. Maybe you get a bonus from work or something, you dump some more money into it. When you pay it off early, they could charge you a penalty. And whether or not they can do that or not needs to be spelled out in the loan, in the promissory note. Prepayment penalties do not affect all loans. Specifically, The lender can't charge a prepayment penalty on an FHA loan or a VA loan. We'll talk about FHA and VA loans. They also cannot charge a prepayment penalty on conventional loans, for example, that are less than 150,000. So there are some exceptions. So basically, if you get a conventional loan for more than 150,000, you may or may not have to pay a prepayment penalty. That'll be spelled out in the note. I know after this unit, a lot of my homeowners want to start throwing more money at the bank. We're going to do some calculations. I'm going to show you why you might want to start making more than the required monthly payment. But before y'all start throwing money at your lender, I need you to either call them or pull out your originating paperwork and see what type of loan you have, see if you can be charged a prepayment penalty. Questions on the words? When it comes to lender world, there are two types of states. And the country is divvied up into two types of states. We're either a title theory state or a lien theory state. Now, obviously, you don't have to know what all the other states are. But what I do want you to know is that North Carolina is a title theory state. North Carolina, we are a title theory state. And before we talk about that, let's first talk about the other guys. What are the lien theory states? Not North Carolina, other states. Which other states? I don't know, doesn't matter. Other states, not North Carolina, may be a lien theory state. And the big difference is the foreclosure process. Lien theory states use something called a judicial foreclosure. Can we make a play on words? Do y'all see the word judge in judicial? Lien theory states have to go through a court process. Foreclosure processes in lien theory states are timely, they're expensive. We do not do a judicial foreclosure in North Carolina, lien theory states. The other big difference in the two is what we call our security instrument. So lien theory states call it a mortgage. The security instrument in lien theory states is the mortgage. Another big difference in the two are the parties involved. So lien theory states are a two-party state. There are two parties. There's the borrower, and then there's the lender. And in a lien theory state, the buyer keeps the legal title. The lender has the mortgage. They've received the note from the borrower. And in exchange, they've received the loan and that legal title. So other states might be a lien theory state. The rest of the country then, including North Carolina, is a title theory state. And in title theory states, our foreclosure process, we use something called the power of sale. This is not a judicial process. The attorney involved, who will meet in a second, the attorney involved has to do a quick small claim, stand up in front of the judge real quick and say, hey, I'm going to do this. And the gavel comes down and the attorney proceeds with the foreclosure. It's not this big, long, lengthy, and costly judicial foreclosure process of lien theory states. Again, play on words. The attorney, acting on behalf of the lender, has been given the power to sell the property in the event of the borrower's default. In North Carolina, when you sign that promissory note, you're giving them the power to sell the property in foreclosure. We don't have to have a judge say it's okay. So not as timely, not as costly, things that happen a little bit more quickly because that permission's already been given. The document used is a deed of trust. So the mortgage and the deed of trust are used interchangeably. Really, the difference comes down to what type of state it is. Title theory, including North Carolina, uses the deed of trust. Lien theory uses the mortgage. You will see them interchangeably. They're both referring to the security instrument. Lien theory states are a two-party state. Title theory states are a three-party state. So we have our borrower, also referred to as the trust or, borrow or, mortgage or. We have our lender, who's often referred to as the beneficiary. And then we have this third party, that's the trustee. And the trustee is our, or the lender's, attorney. The trustee has been handled on behalf of the lender to handle the power of sale foreclosure in the event of the borrower's default. So the borrower gives the lender a note. The lender in exchange gives the borrower the loan. But the lender, the trustee, on behalf of the lender, is going to keep legal title. The borrower in title theory states does not have legal title. Instead, what the borrower gets is equitable title. Equitable title is permission to live there. Equitable title is to do whatever you want to with that property. We may have to get the lender's permission to do major renovations. We'll see that. But equitable title is what gives you the right to live here like it's your own. Somebody else is holding that legal title. It's what they have in the event of the borrower's default. Remember, we don't have to go to a judge to get this. We already have it. The trustee already has it. When the borrower makes their last payment, then that deed, that legal title is reconveyed back to the borrower because the lenders receive the final payment. The lender's out. Once they have that final payment, the lender no longer has an interest in the property. That legal title is given back to the borrower, and the lender goes on when you pay it off. So to see that, title theory, deed of trust states the trustee is the attorney acting on behalf of the lender. They're going to hang on to that legal title, but the borrower is going to have that equitable title. They're going to have the right to use the property. They're going to have the right to possess it, to control the property. You want to rent it out to a tenant? Go for it. It's yours. But the lender has something to hold on to, and what they have is the legal title. Questions about title theory, lien theory states? Let's take our last break. I did play around with some Zoom settings over the weekend, so maybe, just maybe, it won't kick me out at this last break as it's like to. But I think we've kind of learned the drill by now. If it does kick me out, I'll get back to you guys just as soon as I can. So let's take 10. Am I back? Do you see me? Do you hear me? Yay! Tinkering was, well, I don't know. I don't want to get too excited, but it worked at least this time. Welcome back. Welcome back. Ricky, do you want me to put that in the chat, or you just want to hang out after break or after class? You tell me.
You can put it in the chat. It's fine.
Okay. Okay.
Thank
right.
you.
So guys, if you're interested in a study group or inviting Ricky to your study group, where'd it go? There you are. I've permission to share his contact information. I know there were a few of you that met after class last week, or maybe if you didn't and you want to start a study group with permission, I am putting Ricky's contact information in the chat so you can grab him and reach out to him and talk to him about a study group. Thank you, Ricky. And again, I'm always happy to leave the call open after class. All I need to know is to know to do so. Okay, so I am going to welcome back, and I'm going to take attendance. Let's put our lender hat back on and get back into the wild and wonderful world of financing. By the way, do I have any mortgage lenders on the call? Sometimes I do. Getting your mortgage lender license is, similar process. You got to take a class, you got to pass a test, you got to pass a board exam. So it's a similar process. But I know sometimes agents become, sign up for mortgage lending school to get a better understanding, and vice versa. Sometimes our lenders will sign up for pre-licensing to get a better understanding about the process. So these title theory states, deed of trust, legal title, equitable title, when it's paid off, then the borrower gets their legal title, the lender's out of the picture. They'll take their trustee with them. They'll take their lender or their attorney with them. We talked about people that are married when they buy. You may only have one married person on the note, but the lender's probably going to want both on the deed of trust. Remember, the deed of trust is the document that gets recorded. So when an attorney or anybody in the public pulls up this information, they're going to see both names. Sometimes, spouses, the lenders will run their credit both ways. One with both the spouses, one with just one, and see where they get the better rate, get the better deal. So in the event that only one spouse made the note, they will both be on the deed of trust because we are a spousal state, 1 to buy and 2 to sell. It doesn't matter who's on the note, who's on the mortgage. So the borrower and the mortgagor, no matter what state you're in, have rights and duties to each other. This is a contractual agreement. So rights and duties of the borrower. What duties does the borrower owe the lender? Their rights. And as mentioned, first off, they have the right to live there. They can even call it their home. For the most part, they can do with it what they want. That's what that equitable title means. If you have an outstanding mortgage, an outstanding deed of trust, because we're in North Carolina, your lender has that legal title, but you have possession. You can call it your home. Borrowers have the right to redeem themselves in the event of default. Like default has happened, you've missed a payment or whatever. We haven't gone into foreclosure yet. We're close, but we're not there. We're going to talk about a couple of different methods of redemption. Again, it depends on what state you're standing in. So more on that in just a second. And then the borrower also has the right to keep up with the home, the duty to keep up with the home, to do the maintenance. Failure to maintain the home, the basics, could result in the lender taking the property because you're not preserving, you're not protecting their interest in the property. So that's one obligation that the borrower has, is to maintain the home, basic maintenance. And the lender also has rights and obligations to the borrower. And their first right, well, if the borrower doesn't do what they promised to do, the lender has the right to take the property and sell it to get their money back. The borrower's promise is pretty much, I promise to pay you X amount every month for the next however many years. It could be a 10-year loan, a 15-year loan, a 30-year loan, etc. So I promise to pay you X amount every month for the next however many years. And if I fail to do that, then the lender has the right to foreclose, take the property, and get their money back. The lender also has the right to assign the loan. So if they need to sell it to another bank, to another lending institution, they have that right if they choose to assign it. Again, we'll talk more about why they do that. Lots more to come. And then in lien theory states, the lender has the right to deficiency judgment. And title theory states have already been given that right. That's that power sale foreclosure. So lien theory states that deficiency judgment in the event of the borrower's default. Awesome. I just got word somebody else is open to study group. So if you'll connect with Ricky, you guys can definitely form something. And anybody else connect with Ricky. Ricky might be heading this up, putting you guys together, but we got to get y'all to connect somehow. Thank you, Ricky, for, I don't know if you meant to volunteer for all that, but thank you for volunteer. Ricky's going to connect. So you'll probably be hearing from one.
We created a
Actually, I'm
WhatsApp.
not the plug. I
Thank you,
just got
guys.
to invite myself.
Yeah.
Okay, and we may, because I have somebody open to a study group that may not be part of the study group. So maybe we might be forming another one. You guys got to connect. Shirley, did I hear you? Hey.
Yeah, we created a group on WhatsApp last week. We haven't actively studied yet, but I added you to the group, Ricky.
Ricky's on the group. So
Yeah.
Ty, send me your number. I'll get that to Shirley. If that's what you would like. Thank you, Shirley. Ricky, you're in. Brianna, yeah, you guys send me your information, send me your phone number, and I will get that to Shirley. Now I'm volunteering you. You see how you voluntold people what to do? That's what's up. Voluntold. So yeah, y'all just, if you want in, just send me your phone numbers. I'll send them to Shirley. Shirley will get you in. Thank you so much. And Shirley, this may happen like after class, but I'll shoot you a message after class once I get all these numbers.
That's good. Gotcha.
Perfect. Thank you. Okay, so let's wrap this up. Deed of trust or mortgage, again, the only difference in the two is what type of state you are standing in. North Carolina specific is deed of trust. Title theory, I would expect to see this on your practice, even your exams, used interchangeably. So you need to know North Carolina is a deed of trust state, title theory. And another word for a deed of trust is the mortgage. They're both the security instrument. The other document involved in the lending process is the promissory note, the mortgage note. It's the note, it's the IOU. The promissory note is the contractual agreement between the lender and the borrower. The deed of trust is what gets recorded to protect the lender's interest, to protect the lender's money. We're going to talk more about the lender's money. Questions on the two different documents involved with the lending process? Thank you, Ty. Thank you. And Bree. Thank you, Bree. We'll get those to Shirley after class. And anybody else? Just throw me your number and I will connect you. Moving right along. This next section, we're going to talk about different types of sales. So when you're selling a home with a mortgage, you may have some different options, some different things to do. If you're buying a home, you just don't have to get a mortgage. Maybe you're a cash buyer. Maybe we're going to ask for some seller financing, for example. So there's several different options that the parties have. And then in this section, we're also going to get into the major loan types. So this is when we're going to introduce you to conventional loans, FHA loans, VA loans, etc. Some of these more commonly used loans that you can expect your buyers, the most common ones that we can expect our buyers to get. And again, we just need to be familiar with them to help guide them. Ultimately, remember, stay in your lane. Even though we're dedicating a whole unit to financing, that does not make us mortgage lenders. So knowing when to say, I can answer a brief question versus, I don't know, let's get your lender involved and making sure we stay in their lane. So let's first talk about the different types of sales. If you're a borrower that is selling your home, remember, buyer and seller could both be borrower. It just depends on if we're talking about the buyer or the seller. If the seller has an outstanding loan, they have a balance, and they decide to sell their home, the alienation clause, the due on sale clause, would kick in, which means they have to pay that balance off that's due on the sale of the property. And the verbiage, when the borrower is selling their home with an existing mortgage, they are going to do a cash sale. Cash is referring to they're going to pay it off in whole. The seller does not touch this money. It comes straight from the buyer to the closing attorney. The closing attorney divvies out all the money from there. So on behalf of the seller, the closing attorney will send in the final payment, that cash sale, to pay off their loan. The closing attorney will then file a deed of release showing that the seller paid the loan off. And then they will file the deed that conveys property from the seller to the buyer. The attorney has to do things in a very specific order. The timeline has to add up. So before the seller can convey, they have to pay it off. So they'll do the deed of release showing that it's paid off. Cash comes from the buyer. And then they can record the buyer's new deed. So flip that coin. What if you're a buyer? How are you going to pay for your home? Well, you got some options. Cash. Cash is still king, y'all. So if you're a cash buyer, maybe you're an investor, maybe you've been saving a long time, maybe you just sold a home and you use the proceeds from the home you just sold to buy yourself a new one. Cash buyers, brokers, future brokers. If you're working with a cash buyer, we're going to request that they provide us with a proof of funds letter from their bank. Now, I don't need a screenshot of their bank account showing me how much is in their bank. I don't want that. But what I do want is a proof of funds letter from the bank, from their banker, saying, as of this date, this person has X amount of funds. And that X amount of funds is not everything they have in there, but it's enough to show that they can afford to pay for the home. The buyer, the seller is probably going to want to see this. I want you guys to see that proof of funds before you take them out and start showing them a bunch of properties. Because anybody could call you and say, I got cash, I want to buy a house. And then 3 months later, they don't when they're ready to buy. Does that make sense? So save yourself some time and some energy. When they call you and say, I'm a cash buyer, let's go ahead and request that proof of funds. We know we're going to need it when we make the offer anyway. So let's get it now. Make sure you're utilizing your time. I talked very briefly to a buyer once that told me she got money from an estate. She was going to be a cash buyer, money from the estate. And I said, proof of funds, please. Call your banker. I want a letter saying, I don't remember the price range she was looking in, but let's just say a $200,000 home. Said, I need a letter saying that you have at least $215,000 in the bank because that'll cover closing costs, things like that. She dragged her feet. She wanted to go see this property and that property. And y'all, I held tight. She said, well, we don't really have it yet. It's in process. Okay, this is a big difference. Is having the funds the same thing as the funds are on their way? And what she did was prove to me that she didn't have it yet. We're still waiting on it. It's been a time. It's a process. There's a difference and it's coming. So we want to make sure before we show property. If they're not a cash buyer, there's a really good chance that they're going to get a loan through a lender. We'll see the most common loan types in just a few minutes, conventional, FHA, etc. And more on that process in just a second. And then there's some other options, not as frequently used, but they're still out there. So we need to be aware of them. We need to be familiar with them in case it comes up. You may choose to go to your BIC. Lenders are not involved. So you may choose to go for your BIC or your lender buddy for more guidance. But some other types of financing that we're just not seeing much anymore. You could finance a home subject to the mortgage. You could also finance a home assuming the mortgage. The buyer that buys subject to, they're going to take the seller's debt. Either one of these is taking the seller's debt. But if they buy subject to, check it out. Buyer misses a payment and 2 payments and 4 payments. Who are they coming after? Yeah, the seller. Put yourself in the seller's shoes. Are you going to sign up for this? Hey, stranger that I've met before my entire life, take this subject to and leave me liable. You see why we don't do this much? I think if we did come across this, it might be like a family situation, for example. You're not going to have an arm's length transaction. Arm's length transaction is referring to the people do not know each other. They're not in cahoots. But the buyer, this could be an option. Probably want to get a real estate attorney involved. Start with your BIC. If this comes up for you, start with your BIC. Another option to do not use the lender is to assume the mortgage. Again, the buyer's still taking on the seller's debt. But now the buyer's liable, the buyer's responsible. I think assumptions, loan assumptions, are a little bit more common, but we still don't see them a whole lot. And part of the reason why we don't see them is because many of our notes have that due on sale clause. So your whole amount is due on the sale of the property. You wouldn't be able to transfer your mortgage to another party. It is due when you sell it. So if this due on sale clause is part of the loan, then we will not be able to do an assumption. The buyer will not be able to take on the seller's debt. You may have heard of something called seller financing. Maybe the seller will act as the lending institution. The buyer will just pay the seller directly, for example. We have other options out there. Lots of ways to buy a house. So let's get back to I'm going to go back for just a second. Let's get back to the mortgage piece of it. We got the cash piece and that we just discussed the others. So let's get back to the mortgage piece of it. And through the eyes of the lender, when you march into a bank and say, I want to buy a house, give me money. The first question the lender cares about is, what is my loan to value ratio? The loan to value ratio is the lender's ratio. And the loan to value ratio helps the lender determine the maximum amount that the bank is willing to lend. The loan to value ratio tells the lender, based off of the value of this property, what is the maximum amount that I'm willing to lend. T-bar fans, rejoice. We can calculate the lender's loan to value ratio by using the T-bar. More than likely, we're going to be given the loan amount and the value. And the question may ask, what is the loan to value ratio? What is the lender's loan to value ratio? So for example, and we need to see this difference here through the eyes of the lender versus the eyes of the borrower, which we probably have a better understanding on. So you're wanting to buy a home that's priced at $250,000. You found your dream home and it is $250,000. And you go into the bank and you say, I've bought a home. I want to buy a home that's $250,000. Give me $200,000 so I can do this. The lender's first question is going to be, what is my loan to value ratio? So the back fourth line in the T-bar means divide. And when we take the loan amount and divide it by the value, I get the lender's ratio of 80%. If you're asking the lender for 80%, what is the borrower's down payment? I can see mouths move. Yep. You're asking for 80%. That means your down payment is 20%. Please do not get the borrower's down payment mixed up with the lender's loan to value ratio. Questions? So one piece of math, and I told y'all there was lots of math in this unit, yes? Okay, just in case I didn't. So piece number one, here's our loan to value ratio T-bar. We'll see this, we're just building up to it. The other thing to take into consideration, that loan to value ratio. What does the lender define as value? The lender defines value as the sales price or the appraisal amount, whichever one is less. They will only originate the loan, the value in their loan to value ratio will only be originated on the lesser of the two numbers. So let's say, for example, you put your buyer under contract and our sales price, what did we just say? You're buying a home for $250,000. Congratulations, folks. We're under contract to purchase my home for $250,000. As part of the buyer's contract to closing process, they're going to order the appraisal. More on that. The appraisal comes in, let's make some numbers up. The appraisal comes in at $240,000. Which one? Show me. Option one is the sales price. Option two is the appraisal. Which one is the lender going to originate the loan off of? Option one or option two? And I'm seeing two. It's going to be the lesser of the two. So let's talk about what this means. The buyer is contractually obligated to buy the seller's home for $250,000. We have a signed contract in our hand. The appraisal comes in at $240,000. The lender says, I will only give you 80% of the value. I'll only give you 80% of the $240,000. So I got $10,000 discrepancy that we got to figure out, right? As the buyer's agent, I'm going to go to the seller first and ask them to renegotiate the purchase price. Actually, I'm going to ask them to come off $10,000 on the purchase price. Is the seller under any obligation to renegotiate? No. We're locked in, folks, for $250. I can ask, but the seller has every right to say, nope, not going to do it. So now my next step, I'm going to go to my buyer. You got $10,000 laying around. They're not going to be able to borrow this money because they're already trying to get a loan to purchase the home. So they probably won't be able to borrow it. And that does include borrowing from private funds. And an example of private funds are the bank of mom and dad. So it's not that they're not going to be able to borrow it from the bank. They're not going to be able to borrow it from anybody because the lender's saying, whoa, 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 you already owe me 80%. If you borrow more money, I'm concerned you won't pay me back. I have concerns. If mom and dad, the bank of mom and dad get involved, could mom and dad gift the $10,000? Do we hear the difference in borrowing 10 grand versus gifting 10 grand? I guarantee you the lender would make mom and dad sign something that says this is a gift and we do not expect to be paid back. And if mom and dad lie, that's called mortgage fraud. And that's really, really bad, really bad. So the money could be gifted, more than likely not borrowed. It'd be a case-by-case situation. A third option could be, let's have the seller come down 5 grand and the buyer come up with 5 grand on their own. We could see if we can't meet in the middle if the seller's willing to work with us. But if the seller's holding tight at 250 and the buyer doesn't have $10,000 laying around or they can't find it, game over. We're not going to get loan approval because the lender will only originate the loan on the lesser of the two. Next unit, unit 7, we're going to get into our comps, into our CMAs, and we're going to talk about why the accuracy of my comps is important. And just to give you the preview, the answer to that is right here. When I'm determining list price, when I'm determining offer price, I need to try to get close to what we think it will appraise for so we can best advise our buyers and sellers. Questions on this? So the lesser of the two. By the way, as part of that buyer's contract to close process, the appraisal, if they're using a lender, the appraisal is a must. The lender requires the appraisal. The appraisal is the property of the lender. But guess what? They let the buyer pay for it. Isn't that nice? But it is the property of the appraiser, the lender, and it's for them to determine their loan to value ratio. You know, a couple of years ago, some of you may have been familiar with the housing market, pandemic, post-pandemic, and it was crazy. It was like the wild, wild west out there. So we were seeing stuff, y'all, I'm not making this up. We got a sales price maybe of 200. Actually, let's back that up. I've had a list price. The property was on the market for 175,000. The sales price was 250 and the appraisal was coming in with what we listed it at. If the buyer's willing to pay $75,000 more than the list price, yes, this happened. This was a reality around the pandemic. It was listed for 175. It was listed right. It was priced right. It was priced to sell, but competition got so fierce, buyers were driving up that listing price. And what They needed to understand, and what I hope their agents and their lenders were explaining to them is you are starting out. First off, you got to have the 75 grand laying around because we know the seller's not going to renegotiate that price down from the 250. But they had to understand that they were buying underwater. They were buying with owing more than what the property was worth. We're not really in that market anymore. We're still in a seller's market, but the pandemic seller's market was like a ridiculously absurd market. We're not there now. We're more down to normal, whatever that means. But dealing with these things, knowing the market and keeping up with it is all part of what we can do to help our buyers and sellers in that market. Nothing I can do to control the market. Nothing I can do. All I can do is educate my buyers and sellers about the market that they are buying and selling in. Any comments on that? Questions? So the three different loan types, we got several different loan products, and usually, typically speaking, this is all subject to change, but of course, this just gives us an idea. A lot of borrowers, if they're going for a conventional loan, they could have a loan to value ratio of 80%. Like we decided, if you're asking the bank for 80%, then your down payment is 20%. You are bringing 20% to the table. This is just an example. But 80%, 90% is pretty typical for conventional. Buyers that are going FHA might be able to qualify for a loan to value ratio of 96.5%. If the lender's bringing 96.5%, what's the buyer's down payment? Like 3.5, right? You have a smaller down payment, but guess what? With the FHA loan, we're going to learn you have tighter criteria, tighter restrictions. So not all borrowers may apply for an FHA loan, for example. Another type of loan we have, y'all ready? Our VA loan is awesome. Eligible veterans can apply for a VA loan of 100% loan to value ratio, which means your down payment is how much? Yeah, isn't that nice? The VA, $0. The VA is a great program for our veterans. We will talk more about each of these loan types. We're getting there, better understanding of. And again, there's more strict, there's more criteria. So as we've been saying, which one has the highest loan to value ratio? And looking through the eyes of the lender, they're giving the most money. They're originating the more loan on the VA loan. Which one has the highest down payment? And the highest down payment would be, in this example, the conventional loan. Yep. So understanding when we see this number, this LTV, this is through the eyes. Yep. This is through the eyes of the lender. So we got some fun math to do. Kind of taking that pie. Part of it is the lender's loan amount that they're giving you. The other part of it is the borrower's down payment. And the lender will talk to, they'll work with the buyer. Like you're applying for this conventional loan based on your debt to income ratio. I need a loan to value ratio of 80%. So if you don't have at least 20%, and some extra money for closing costs, all that stuff adds up. That's usually the first start of the conversation. How much do you have for a down payment? By the way, we'll get into all those closing costs. All that's coming. So let's use that loan to value ratio. You have a 200,000 sales price with 195,000 appraisal and a loan to value ratio of 85%. My question to you is, what is the loan amount? And you're welcome to share in a chat. I'll give you guys a minute or so. So I got a couple of different things going on. I got a sales price and I got an appraised amount, and I have a rate or a percent. So I may not know what else, but what I do know is that I can throw down my T-bar. And I think Julie said once that the rate or percent always goes in the bottom right. Take that guesswork out of it. Rate or percent always goes in the bottom right. Now I got a sales price and appraised amount, and I'm also looking for the loan amount. So T-Bar 101 teaches us part over the whole. Is your loan amount more than or less than the sales price or the appraised amount? The loan amount is going to be less than what you buy the home for. So in this case, what we're solving for is that number on top. And then I got a sales price, option number 1, or an appraised amount, option number 2. Show me, which one are we going to use? Option number 1 or option number 2? And we're going to use option number 2 because the lender will originate the loan on the lesser. So we went under contract for 200. The appraisal came back at 195. This is what the borrower will, the lender will originate the loan on. Up, down line in the T-bar means multiply. So I take my appraised amount, the value of the home times 85%, which means you're getting a loan amount of 165,750. The borrower's down payment then would be 15%. I'll let you do that math if you want to. Questions on the loan to value ratio? Can I erase? So as we're seeing, most lenders require some kind of down payment. The exception would be the VA loan if they qualify for 100%. Just because you're a veteran does not mean you're automatically guaranteed that 100%. It's an option. It's not uncommon for a vet to get a VA loan with some kind of down payment. And this gets us into another financing term to understand, and that term is equity. A big benefit of home ownership is to build equity. And equity is your money. Equity is the money you have invested in your property. So the day you buy your home, that down payment is your initial equity. And throughout ownership, the hope is that you build your equity. There's a very simple formula for equity, and it's just the difference in the value of the property. What is it worth today? Minus your outstanding loan with the lender, your outstanding mortgage, your outstanding debt. So again, you bought a home today I'm trying to remember our previous numbers here. We determined the value was 250. Your down payment. Yeah, your down payment was 50,000. It was 20%. So your debt, sorry, your value minus what you borrowed from the bank. There it is. So your down payment, your equity on day one is $50,000. As long as you show up with a down payment and you're not paying more, as we saw in the pandemic, you begin your home ownership journey with some equity. And as time goes on, the hope, that American dream, is to build your equity. And there's 3 different ways that'll build your equity. And they all revolve around increasing value and decreasing debt. So the 3 things we can do to build your equity. Appreciation. Appreciation is the increase in value for any reason. During the pandemic, everybody went through appreciation because buyers were paying $75,000, for example, more than asking prices. A lot of areas, a lot of markets across the country had appreciation. You could also have an increase of value. What if we rezone? And the rezoning increases the value. You've got appreciation just by what's happening around you, what's happening to the market and the values around you. Another thing you can do to increase your value are capital improvements. Capital improvements are improvements to the property of substance. Painting a room is not a capital improvement. Adding a room to the back of the house is. Finishing the unfinished basement. We're increasing square footage. And when you increase that square footage, we're going to build that equity. So appreciation will add to value. Capital improvements will add to value. And then the other way you can build your equity, pay your bills, pay your mortgage. So you pay down that debt, that equity grows. It takes time to build equity, again, especially if somebody paid more than the appraised price, more than the purchase price. If they were about maxed out, the lender says you're approved for 250 and your buyer wants to buy it, 249, 999, they're maxed out. They're at the tippy top of their approved amount. That may take them a little bit longer. I don't think home ownership was ever meant for short-term ownership, because the whole point is to have that equity. And if you only have it for a couple years, it's awfully hard to build up. Questions about equity? Questions about anything? So I know we're a few minutes early, but y'all know by now I don't go anywhere yet. I don't like to start something just to stop within a couple minutes. So before we get into this next section, I'm going to go ahead, I hope, and get us out of here. Let's see, a couple things. Are you guys looking at each other again? Do you guys see each other? Okay, good. Couple things. Thursday, we're still in Unit 6. We will be in Unit 6 on Thursday. We might get close to being done, but I doubt we'll wrap it up. Because I'm not expecting to wrap up Unit 6 on Thursday, we're not going to do the midterm until a week from Tuesday. And again, we will talk about that next week. So just mentally prepare yourself. Maybe set aside the time. You need about 2 hours. It's a one-time sitting, a one and done. You can't come back to it later. Allow yourself about 2 hours, and your midterm will be available to you after class next week. So that'll give us time to wrap up 6, make sure we've said everything before you guys look at that midterm. The midterm is going to be on the first 6 units. So I think this is a great time to start reviewing, going back. We had a lot about agency. Y'all know what you can expect to see a lot on your midterm. Agency, I think, is pretty reflective of the weight of the exam. So we will do that next week. Again, I'm going to leave the test open for a week. So you'll have from Tuesday till that next Monday night. So that's coming. Like I said, also, when we're done with Unit 6, again, next week, we're going to look at that application process. So Unit 6, and then we'll take a little breather and talk about your application. And then that'll get us into next week. So we'll know better where we are on Thursday and what to expect for next week. Do I have any questions, comments, or concerns? No problem, Raj. It just happens sometimes. Thank you for your patience. I'm around. If you guys have any questions, please don't hesitate to reach out to me. Shirley, I'll send you an email after class. I got 2 more phone numbers for you to add. So I'll send that to you. Let me eat lunch first, and then I'll send that to you when I'm done eating, and then you can get them added. If you still want to be added to the study group, I now know who the contact is, so I can help. I can help connect you. And that's what I have for today. Y'all have a good afternoon. Enjoy your day tomorrow. We'll do it again on Thursday.